There is a direction to list this case after disposal of one of the matter of TGT teachers which is listed on 19/6/2024. So I only think that this case may also be listed with the main case on 19/6/2024.
टेक द कंसेंट अभी आप लोग लिस्ट करा देते हैं उसके बाद बोलते हैं इससे कोई लेना देना नहीं.
So I will take the consent and
You
give
take
the
the consent from the other side.
Yes.
और आप लोग प्लीज आउट ऑफ लिस्ट आपको बोले हुए हैं ना यहाँ पे नहीं है बताते नहीं है क्या आप
नहीं बताया था
तो
बताया.
मेंशनिंग रिजेक्टेड. अगर आप हमारे इंस्ट्रक्शंस को नहीं फॉलो करेंगे तो हम आपके रिक्वेस्ट को नहीं मान सकते.
So there is a office note
इस
that
केस में जुडिशियल ऑर्डर है
Judicial.
कि एक सर्टेन केस के डिस्पोजल के बाद उसको लिस्ट करना है.
वो केस 19 तारीख को लगा हुआ तो मेरा इतना रिक्वेस्ट इसको भी 19 को लगा दिया जाए. सेम मैटर एग्जैक्टली सेम मैटर है टीजीटी टीचर्स का.
अदर साइड से कंसेंट लेके
ठीक है ना.
और ऑर्डर शीट लास्ट ऑर्डर लगा के लेके तब देखें.
अच्छा.
From the list, serial number 63, Your Lordship. I'm praying that this matter may be taken up any time during the day.
What is the matter?
Matter relates to petitioner. There are 4 petitioners seeking promotion on the basis of seniority. The rules are in their favor. They have attained they fulfill all the criteria. Now the department has given officiating charge to persons who are 8 to 10 years juniors to them, and they are at the verge of superannuation, Your Lordship. Petitioner number 1 has already superannuated in the month of December, so for him the writ petition has become infructuous. So far as petitioner number 2 is concerned,
Affidavit filed?
yes, counter has been filed, Your Lordship, and
No rejoinder is
not
required.
required, Your Lordship, because they have also said that they are going to consider the matter. However, they are delaying the DPC on one account or the other. If they conduct the DPC in proper manner, everything will be sorted, Your Lordship. And
They are those who are officiating the post, they are junior.
much junior, 6 to 7 years juniors, and that has been brought on record, Your Lordship. And they are holding more than one offices in officiating capacity. So, Your Ladyship, anytime during the
When was the last DPC held?
Your Ladyship, last DPC was held in the month of February. Thereafter, they have again sent the file for reconsideration on some account. Since we are the first 4 persons who were there in the seniority list, but our cases are not being considered. Again, it is under consideration, and they will take up another 2 months. And petitioner number 2 is going to retire in the month of May itself, and the rest of the remaining petitioners in subsequent months of this year, Your Ladyship. So only praying that it may be taken up today at any point of time.
Very difficult to pass a direction that on a particular date DPC is to. They have, as per their circular, they have to conduct DPC twice a year.
Twice a year.
So
And
they have already done in February.
they are doing it in the month of February, which they conducted was of 2023. December
We do
they
not
did not
know.
conduct.
For 1 year, they have every
Conduct.
year they have to conduct DPC twice.
Yes.
Anyways, we'll hear it tomorrow. कल कर दीजिए.
Tomorrow.
मुश्किल है इस तरह का डायरेक्शन देना. Very difficult to give a direction to conduct a DPC.
A time may be fixed at 2:15 or 12:30.
सब आपके अनुसार नहीं होता है ना.
नहीं,
जब आप
हम
मेंशन
only
किए हैं तो
trying-
you wait for your turn whenever it is taken.
Tomorrow, Your Ladyship. Of late.
63. Inform the other side.
I have
They should
already
not be
informed.
taken by surprise.
Already. Okay.
Orders notified at item 6 WPS 6361 of 123.
One thing kindly be granted to remove the defect.
Counsel for the petitioner prays for and is granted time till 30th April 2024 to remove the surviving defects claim-free. If the defects are removed within the stipulated time, post this case under appropriate heading on 6th of May 24.
For first filing, item 7 WPS 6316 of 2023.
This is for revision of case schedules.
Yes, respondent. He has filed a representation, you consider it? There is no really need to know because we are not going to decide whether he's entitled for. Is there any adverse order passed against you? No adverse order so far. Who will consider your grievance? Respondent number 3.
Respondent number
Before whom have you
three.
represented? Respondent number 3. Vicky. The learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel submits that no adverse order as such has been passed against the petitioner, and the claim regarding revision of pay scale has been raised, and a representation is pending before the respondent number 3. The learned counsel has submitted that the petitioner has all the necessary documents to support his
Not
case.
this is second round of litigation.
Maybe how does that make a difference?
Earlier also representation was disposed after the order was.
Earlier the claim was something else. Earlier it was for post-retiral benefits.
Yes.
Now you are claiming revision of
Three.
pay scale. Technically you did not raise this issue at that point of time. So it can be even barred by res judicata. But since it's pay scale, we will not say anything more. You should have raised all your grievances at one go.
Yes.
2007 का और कब का पुराना? What is the oldest time you are claiming? 2007, 2008. You slept over your rights. इसीलिए लिखा रहे हैं that you have all the necessary documents to support your case. The learned counsel for the petitioner has submitted that he is in possession of all the required documents to support his claim for revision of pay, and the matter is pending before respondent number 3. Counsel for the respondents has. You are for respondent number 3 also?
No, I am for the state only.
Where is respondent number 3? Counsel for the respondent state has submitted that. Respondent number 3 की तरफ से कोई तो किसी को तो सर्व किए होंगे. Is there any standing counsel for respondent number 3?
Yes, ma'am.
Who? Sorry?
Name of Mr.
He is appearing. He has been served.
Mahavir Prasad Sinha.
Counsel for the respondent state is present. He submits that the appropriate order is to be passed by respondent number 3, before whom the representation is pending. Nobody is appearing on behalf of respondent number 2 and 3, although as per the records, although the counsel for the petitioner submits that copies of the petition has been served upon Mr. Mahavir Prasad Sinha, advocate, who is the retained counsel for respondent number 2 and 3. After hearing the learned counsel for the petitioner and respondent state, and upon going through the records of this case, this court finds that no adverse order in connection with the revision of pay scale of the petitioner has been placed on record, and as per the records, the petitioner has moved for redressal of his grievance before respondent number 3, which is pending consideration. The petitioner had earlier moved this court in WPS number 5299 of 2014 for his retiral dues and other dues, but it is not clear as to whether the petitioner had ever raised his grievance in connection with revision of pay scale. Considering the nature of relief sought for in this petition, this court is not inclined to call for a counter affidavit in the present case. However, the respondent number
2 and
3 is directed to respondent number 2 and 3.
2 and 3
दोनों जने ऑर्डर पास करेंगे कि कौन ऑर्डर पास करेगा?
सेक्रेटरी करेंगे जो रेस्पॉन्ड नंबर 3
हाँ, आप किसकी तरफ से हैं?
अब 2 and 3 की तरफ से फिर करेंगे।
अच्छा भाई, इनका नाम दे दीजिए।
संतोष कुमार झा एसी टू मिस्टर महावीर प्रसाद।
दीजिए, लिख के दीजिए। इनका नॉन अपीयरेंस डिलीट कर दीजिएगा। इनका भी लिख दीजिएगा। The grievance of the petitioner can be looked into by respondent number 2 and 3. Who will pass the order? 2 or 3?
3 lords सेक्रेटरी।
Accordingly, this petition is disposed of, enabling the petitioner to approach the respondent number 3 by filing a representation along with all the supporting documents and a copy of this writ record, who shall consider the grievance of the petitioner and pass a reasoned order in connection with his claim within a period of 15 days, within a period of 4 weeks from the date of filing of representation,
8 वीक कर देगा।
after verification of the records, the reasoned order be communicated to the petitioner through speed post, after granting an opportunity of hearing. Yes?
Second place with regard to ACP, first and second ACP.
Everything, whatever it is, whatever grievance you have raised, that will be considered.
8 वीक खाली कर दिया जाएगा।
If the petitioner is found entitled for any financial benefits out of the recent order, appropriate follow-up orders be also passed so that the monetary benefit out of the recent order be also remitted to the petitioner within a period of 6 months from the date of the recent order. इनका पे रिविजन होगा, इनका पेंशन वेंशन सब रिवाइज हो जाएगा।
उस हो जाएगा। हमारे यहाँ भी पेंशन नहीं है,
नहीं है।
हमारा पेंशन नहीं है, रिटायरमेंट बेनिफिट है।
जो भी है whatever,
उसमें भी
because ACP होने से सब चीज रिवाइज
जो भी
होगा।
है इनको एज पर स्कीम जो हमारा प्रिविलेज स्कीम है उसमें इनको मिलेगा।
Item 8, WPS 6649 of 2023.
This petition is prepared for entire retirement benefits, payment of entire retirement benefits along with the statutory interest reduction. The petitioner retired on 31st of October 2022. 31/10/2022, altogether rendering a service of 32 years and 10 months. On 22nd of February, this case was listed before the Honorable Court, Your Lordship, wherein the respondents were directed to bring the check of the entire amount. The petitioner has neither been informed till date that what is the actual admissible amount of the retirement benefits, Your Lordship.
We'll ask him to do the needful. Who will do the needful? Will how much time do you need to take a decision on his retirement benefits and remit the payment? Yes, respondents? You tell us how much time.
4 weeks or so.
4 weeks में हो जाएगा इनका काम? क्योंकि अगर आप जितना टाइम बोलेंगे उतना दिन में नहीं करेंगे ना, तो कुछ इंटरेस्ट का पेमेंट भी हम करेंगे, इसीलिए आपसे एकदम पूछ रहे हैं कितना आपको टाइम चाहिए।
6 weeks कर देंगे।
6 weeks कर देंगे। लेकिन नहीं किए तो इंटरेस्ट लगेगा, राइट? ओके, इफ यू डू नॉट रेमिट द अमाउंट यू विल हैव टू पे द इंटरेस्ट।
और सिर्फ एक्चुअली
8 वीक्स कर रहे,
अभी कोड ऑफ कंडक्ट की वजह से कुछ काम
पेंशन बंद कर दिए हैं,
नहीं बंद नहीं किया उसे,
फिर क्या?
थोड़ा सा ये वाला तो थोड़ा सा बढ़ा के टाइम 8
कितना आपसे पूछ रहे हैं आपको कितना टाइम चाहिए? कोड ऑफ कंडक्ट के बाद आप छुट्टी पे जा रहे हैं, पता नहीं। पेंशन रोक दिया लोगों का, मना कर दिया है कि पेंशन नहीं देंगे।
22 में रिटायर हुए।
नहीं एक्चुअली
आप तो बोलिए ही मत, 92 से लेके अब तक क्या कर रहे हैं?
बस ना, अभी रिटायरमेंट अभी हुआ है।
ठीक है, बताइए कितना टाइम आपको?
8 वीक्स
8 नहीं देंगे तो कितना रेट ऑफ इंटरेस्ट हम फिक्स कर दें? आप ही बता दीजिए।
हो जाएगा।
नहीं बताइए, अगर नहीं करेंगे तो इट्स योर चॉइस।
बेटर होगा लॉर्डशिप हमको काउंटर फाइल करने दे,
कोई काउंटर का काम ही नहीं है,
क्योंकि बिना इंस्ट्रक्शन के मैं कैसे बोल सकता
बिना इंस्ट्रक्शन के तो कुछ भी नहीं बोल सकते हैं। आपको पहले भी डायरेक्शन हुआ था काउंटर फाइल करने के लिए, आपको डायरेक्शन हुआ था पेमेंट करने के लिए।
काउंटर के लिए लॉर्डशिप नहीं हुआ
पेमेंट करने के लिए हुआ था, कर दिए हैं।
नहीं।
फिर if he is not entitled you pass a reasoned order, reject his claim, right? Admissible dues का पेमेंट का ही ऑर्डर कर, ठीक? देखिए WPS number 6649 of 2023. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner has earlier moved this court in WPS number 3818 of 2018, and the services of the petitioner has been regularized with effect from 5/11/1989. But the pensionary benefits have not been extended to the petitioner. He submits that the petitioner is entitled for pension, and the judgment passed in WPS number 3818 of 2018 dated, date बताइए, 3/2/2022 has attained finality. इसका फॉलो अप ऑर्डर पास हुआ था, डेट ऑफ रेगुलराइजेशन देते हुए कुछ ऑर्डर हुआ था।
उसके बाद तो रेगुलराइज हम रिप्रेजेंटेशन दिए तो मेरा सर्विसेज को रेगुलराइज कर दिया गया था। उसके बाद फिर कंटेम्प्ट रेफर किए थे।
ठीक, the learned counsel has submitted that pursuant to order dated 3/2/2022 passed in WPS number 3818 of 2018, the services of the petitioner has been regularized, but pension has not been paid. On 22/2/2024, the matter was directed to be placed before National Lok Adalat, and following order was passed. However, the payment could not be extended, and the matter could not be settled in National Lok Adalat. As per the writ records, no adverse order in connection with the claim of the petitioner for post-retirement benefits has been placed on record. Considering the nature of the relief as prayed for in this case, this court is not inclined to call for a counter affidavit in the present case. However, the petitioner having raised his grievance before respond number
4, Your Lordship. 6, Your Lordship. The circle officer marked the request.
However, the petitioner has raised his grievance before respond number 6. Considering the nature of relief as prayed for, this court is of the view that the matter can be looked into by respond number 5. Deputy Collector establishment or by the respond number 4.
4, Your Lordship.
By the respond number 4. Accordingly, this writ petition is disposed of, enabling the petitioner to approach the respond number 4 by filing a detailed representation along with a copy of the writ records within a period of 15 days from today.
Yes,
Upon
sir.
filing of such representation, the respond number 4 is directed to pass a reasoned order with regard to the claim of the petitioner after granting an opportunity of hearing to the petitioner within a period of 8 weeks from the date of the representation. The reasoned order be communicated to the petitioner through speed post. If the petitioner is found entitled to pension and other retiral benefits arising out of the reasoned order, appropriate follow-up orders be passed so that the monetary benefit out of the reasoned order is remitted to the petitioner within a period of 6 months from the date of the reasoned order. आपका PF का भी claim है.
Yes, sir.
The respond number 4 shall call for necessary records and details from the other respondents with regard to the claim of the petitioner, particularly the respond number 7, while passing the reasoned order. Details चाहिए ना?
Yes, sir.
This petition is accordingly decided.
Obliged.
एक चीज़ और, if the admissible amount is not paid to the petitioner within the stipulated time, the petitioner would be entitled for interest at the rate of 6% from today till the date of payment. Simple interest.
For admission item 9, the LPS 5114 of 2021.
He has been convicted. He has been convicted in the
I know he has been acquitted now.
acquitted.
But acquittal was after his joining. He was joined in 2013 and he acquitted by an order dated 10/3/2017.
Amendment has been allowed. Amendment has been allowed.
Amendment has been brought. We have also filed a counter affidavit to the effect.
When do you want?
Not today.
Not today means tomorrow. हंसने की बात तो नहीं है. Not today का क्या मतलब? Readings are complete.
It is complete. Only I have to bring one judgment of this honorable court. A similar matter has been decided by your lordship.
What similar matter?
It's similar to the facts of the case.
They have not filed the rejoinder. Do you want to file any rejoinder? Rejoinder file करना है आपको? Yes. कौन है आपके सीनियर? जो आज कोर्ट नहीं आए? WPS number 5114 of 2021. Counsel for the parties are present. Counsel for the petitioner prays for adjournment. On the ground that arguing counsel Mr. Anand Kumar Sinha is not well and he has not come to the court. In spite of order passed by this court, rejoinder has not been filed. Pose this case on 24th of June under the heading for final disposal. Rejoinder, if any, may be filed latest by 12th of June 2024, failing which no further time will be granted and the case will be decided on the basis of materials available on the court. आप पिटिशनर नहीं फाइल करेंगे सिनॉप्सिस, आप फाइल कर दीजिए. जैसा लग रहा है इनको देख के कुछ करने वाले नहीं हैं. ठीक है.
Item 10 WPS 564 of 2023 along with item 11 and 12.
All the three matters involving the same fact. It is similar issue has been the matter has been remitted back to the respondent file. This is the order not passed by this one. Exactly the same claim. You just having the claim of the petitioners in the three cases below. They are covered by that order. The matter has been remitted back to the respondent file to decide the representation in the light of the judgment of the Supreme Court, which we are also relying in para 1 I have stated. I have shown to my learned friend also.
Is that correct?
Matter will be remitted.
Is the respondent number?
Now, my lord, here in that case it is respondent number 5.
It is respondent number 2, my lords. In serial number 10, my lords.
Principal Secretary,
Yes,
Yes.
school education.
School education.
Yes.
Is there any adverse order passed? Something is required to be
No,
set aside?
no order has been passed. In fact, they kept silent. The Honorable Supreme Court, if Lordship may like to see Annexure 2. Annexure 2 exactly covers our cases. In case of course it arises out of a judgment rendered by the Honorable Patna High Court, present Patna High Court. Annexure 2, page 46. That was challenged by the state of Bihar and others. And the Honorable Supreme Court has held, my lord, subject to Lordship's kind page 46. The ultimate, the Lordship may see, my lord, that the ultimate finding, first of all, it is covered by advertisement number 1 by 87. We are also covered by the advertisement number 1 by 87. This is the case. Then, my lordship may kindly see the ultimate finding of the Honorable Supreme Court.
Page number 77.
Page 30, para 37, page
Should it
77.
be suffice that I say that in terms of this order it is disposed of,
Yes,
right? From where do I get the details in para number 2 which is mentioned?
yes. So far we are concerned, but we have also given
Where is the
the
details?
details to the Lordship may kindly see.
Page number 16.
Page number, para 15,
Page number 16.
Okay.
page 16, para 15. Details I have given, not petitioner wise.
The petitioner wise details are there in all the repetitions.
In your serial number 12, it is in paragraph 10, page number 10. In my lordship, serial number 11, it is in paragraph 8.
Only the paragraph numbers are different, otherwise
You have made a chart.
In 4438,
Yes, it is para 8 number. Chart I have prepared, page number 11.
विनीत जी है, इसको स्कैन करके बता था, टाइप क्या करना, ठीक है।
Page 10 of the report.
Draw 3 separate orders, right? In WPS 369 of 23, the chart is at para 10.
Only one thing, in column number 8, it has been mentioned that he is going to retire on 31st. Date number 11, so now he has retired.
That's right, it has,
Yes.
we'll just scan the chart.
Yes.
Don't worry about it. Now, so far as 4438 of 23 is concerned, the
Right.
chart is at para 8. And so far as WPS number 564
Para 15.
of 23 is concerned, the chart is at para 15. The judgment was passed by Patna High Court in undivided Bihar or
No, it is divided.
Divided.
After.
Therefore, state of
After
Bihar has
the
challenged in Honorable Supreme Court Annex 2, page 46 in my brief. The first case. Civil Appeal 7364 of 2014. Page 46.
yes,
Along with analogous civil appeals.
that's right.
Same has been quoted in the order which I have placed before Lord Supreme Court coordinator.
फिर WPS अंदर एक का ऑर्डर लिखा था, बताइए कौन सा लिखा है, ये वाला. What is the response of the counter affidavit में क्या है? What is there in the counter affidavit?
Malot, the relevant.
They have quoted the judgment which is not applicable in our case, that is primary school teachers. They are not, the petitioners are not those teachers. They are covered by advertisement number 14 by 87. They could not distinguish the judgment of the Honorable Supreme Court. Para 19.
आप अपना काउंटर प्लेस करेंगे कि पिटिशनर?
No, my lord, I will place my lord. I will place my counter. My lord will kindly see, my lords, the relevant paragraph, note that we have. Note that paragraph 16 of the counter affidavit at page number 12, my lords. We have stated, my lords, that the appointments of the petitioners were, my lords, temporary in nature, my lords, and they, my lord, they continued into the service without any encadrement, my lords. Now, my lords, in paragraph 18, my lords, we have stated, my lords, that the petitioners have claimed that they have preferred the representation before the respondent authorities to create their cadre merger, which is not correct. Rather, the state government has already decided, my lords, that the cadre of +2 schools of teacher by issuing the notification
Where is
my
the
lord, in
decision?
paragraph 20, my lords, that is something, my lord, what we have stated, my lords, that the appointment process of, my lord, the state education service officers and the lecturers in the +2 government schools are very different, my lords. This is what we have stated in paragraph 20, my lords, at page number 16. And
They are
in
seeking merger.
Yeah, they are seeking merger, my lords. Now, my lord, in paragraph 21 of the counter affidavit, but this is again, my lords, important, my lord, that, my lords, I'll just read this. That the claim of the petitioner for promotion or encadrement in the state education service cannot be considered because the appointment process and the service conditions of the postgraduate teachers
including the lecturers and the state education service officers, is quite different. The state education service officers are appointed through the State Public Service Commission as gazetted officers on class 2 post, while the petitioners were appointed through Vidyalaya Seva Board on class 3 post. Now, my lords, in paragraph 22, my lords, the next paragraph also, my lords, we have stated, my lords, that Jharkhand plus 2 Vidyalaya teachers and staff appointment service conditions rules. In this, my lord, the post of postgraduate teachers of plus 2 schools are appointed on the recommendation of JPSC, my lord, of the Jharkhand State Selection Commission. Therefore, my lord, the claim of the petitioner to encadre them in the state education, my lord, we have stated that it is not sustainable.
इसमें काउंटर फाइल हुआ था इस रेट में?
नहीं, इसका इसमें ऑप्शन कमा.
When this order was passed, any counter was filed?
I will just see. My lord, in this the counter affidavit was not filed.
There is another similar writ petition WPS 1900 of 21.
Yes,
1900.
Where is that order?
Appeal Hussain Prasad.
ये इसका ऑर्डर दीजिए समीर जी. WPS number 1900 of 21.
My lord, this also, my lord, the counter affidavit was not filed. Lord,
In the judgment passed by Honorable Supreme Court and Patna High Court, there was a decision taken by the state government. Some policy decision, something was done by the state government. Is there any corresponding policy decision of the state of Jharkhand?
No.
Then how the case are similar?
No, Your Lordship, may kindly see first of let him complete. I will reply. Your Lordship, may kindly see page 46 again.
You see, this matter has to be decided by a very high ranking officer. ये हम जहाँ तहाँ नहीं भेजेंगे. I'll send it to somebody very high ranking officer because they have to see the policy of the state. We will just simply just a moment. We will just simply say that it has been decided by pursuant to certain decision taken by the state of Bihar and certain orders have been passed, and then he will see the corresponding policy of the state and then pass an order.
No, there is no corresponding policy. What my learned friend has referred, I will distinguish. I have.
You don't need to because there is no adverse order. You see, we are not going to scrutinize it. But it is a matter of policy of the state. If a decision has been taken by state of Bihar post bifurcation, that will not ipso facto apply to the state of Jharkhand.
Your Lordship is correct. Had it been so, my lord, it originated from 187. Advertisement number 187, which is the same advertisement which was appointing the teachers who posted in Bihar Road after cadre division, and the teachers.
Mr. Sani, you have so much of experience, you just can't draw a parallel like this. There can be many policy decisions of the state.
Yes, but my
you have to respect that decision.
But only one thing I want to make it clarify. That what my learned friend has referred to the paragraph, I have responded to it by way of rejoinder, saying that they are referring to the notification or the rule, whatever may be, those are not applicable in the case of the petitioners, which I have stated categorically in my rejoinder.
We'll see. We'll take care.
Therefore, my lord, number one. Number two, the law is laid down by the Honorable Supreme Court. It may be from Bihar or may be from Karnataka.
Has it been laid down
the
that,
law, yes.
That all the recruitments arising out of advertisement number such and
that
such?
is the I was referring to Annex 2. Your Lordship, may kindly see the unfortunately the subject matter before the Honorable Supreme Court and the subject matter before this Honorable Court is the same. For this purpose, I may be permitted to refer to Annex 2, page 46. Maybe, my lord, it arose out of a judgment of the Honorable Patna after cadre division. But Your Lordship, may kindly see it merges into the judgment of the Honorable Supreme Court. Therefore, it is binding. Now, Your Lordship, may kindly see page 46. Your Lordship, just see, my lord. Paragraph 2. Challenge here is to the judgment and order dated 30th April 2013 in CW such and such granted relief to the writ petitioners and declared that the plus 2 lecturers, we are also plus 2 lecturers, both in the government and the nationalized taken over secondary schools, appointed pursuant to advertisement number 1 by 87. We are also appointed by advertisement number 1 by 87 as plus 2 lecturers. Always.
You just come to page number 56.
Page number?
56.
First of all, page 47, I have referred with regard to factual position.
Page
Then you will
56.
see me kindly see paragraph 4.
थोड़ा सा page 56 देख.
Page 56.
6. Para 14.
Yes. During the pendency of the above writ petitions, the High Court, the State Government on 23rd June 2009, in exercise of the powers under Section 9 with Section 15 of the Bihar Non-Government Secondary School taking over such and such, 1981, framed the Bihar sentence. This is the development in Bihar, which has not been done in the case of Jharkhand.
And therefore read para 5 as a
Yes.
result.
Not
Para 15.
As a result, the above Adjournment with the teachers of the national school category further challenge was generated in the High Court by the plus 2 lecturers. It was specifically contended that the plus 2 lecturers have always been treated as above the secondary school teachers in nationalized schools, and therefore encadrement of the two unequals is unjust, which has not been done in the state of Jharkhand. This was done in Patna during the pendency of the writ petition. Therefore, the matter was remitted to in the coordinate which thought it proper to remit it back to the high-ranking officer secretary, so that they may come out. And then thereafter, you will see me kindly see me not
Please listen
the
to the
concluding
order.
part.
WPS number 564 of 2023. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the that the factual background of the case is that state of Bihar constituted a committee in 1976 to address the problem of stagnation
One
in
paragraph,
Bihar
paragraph
civil
37, if
service.
you will see me
Please
kindly
hold on.
see.
In Bihar civil service
Law written
to
on the
consider
Supreme
the
Court.
opportunity for promotion and recommendation of the state committee with respect to Bihar Education Department included the integration of 59 posts in miscellaneous cadre within bracket comprising of teachers, professors, etc., who held isolated posts for no definite prospect of promotion bracket close into the Bihar Education Service.
Paragraph 37, not the ultimate finding of the
Yes,
Supreme
we'll
Court,
see.
which is binding upon
On
the state.
11/4/1977, the then Bihar government issued regulation in line with the state recommendation, upgrading 2465 sanctioned posts of teachers of subordinate education service within bracket male and female cadre bracket close into Bihar Education Service Class 2 with effect from 1/1/1977. With that background, the Association of Teachers had filed a writ petition before Patna High Court, being CWJC number 12122 of 1998, which was allowed by judgment dated 2/2/2000, directing the government of Bihar to act upon the government decision contained in resolution dated 11/4/77, against which LPA number 65 of 2003 was dismissed, and SLP number 6450 of 2003 was also dismissed.
Paragraph 37, if you will see me like, have a look. This is my humble prayer.
I will see that you just hold on for a moment. I'm just giving some background so that they have the feel of
Yes,
the
yes,
subject.
yes.
It is further case of the petitioner that in the year 1979, the government of Bihar introduced 10 plus 2 plus 3 education pattern but there was no sufficient infrastructure and a decision was taken that on 13/11/1985 the government of Bihar sanctioned 148 posts of lecturers in subordinate education service grade for government schools and 264 posts for lecturer for nationalized school, providing common pay scale of rupees 940-1660 for both the cadre of lecturers. And the post of plus 2 lecturers in government schools were specified to be in BS, ES selection grade. Pursuant to the aforesaid decisions, an advertisement number 1 of 1987 was issued initiating the process of selection for class 1 post, that is for lecturers in subordinate service grade in plus 2 stream in government boys/girls schools, and class 1 post as class 1 post, and also for class 2 and class 3 post of subordinate education service within bracket education branch for both male and female. The petitioners were the applicant in the state selection process and were appointed in different schools within the state of Jharkhand, the details of which has been mentioned in paragraph 15, which is quoted as under. It is further case of the petitioner that after the creation of state of Jharkhand, writ petition being CWJC number 18793 of 2008 was filed by different persons who were different similarly situated persons who were inducted pursuant to advertisement number 1 of 1987 and were posted in the newly created state of Bihar, and the said writ petition was decided by common judgment dated 30/4/2013. A copy of the judgment has been annexed as Annexure 1 to the writ petition. The learned counsel submits that the case of the petitioner is squarely covered by the said judgment. He also submits that
Para 37 of that.
he has in particular referred to para 37 of the said judgment.
Where it has been held by the Supreme Court, page 78.
सर या तो आप डिक्टेशन दे दीजिए या हम देंगे, दोनों जने तो नहीं
हम
दे
सिर्फ
सकते।
पॉइंट आउट
हम सिर्फ बैकग्राउंड इसलिए दे रहे हैं कि डिसीजन सही से होना चाहिए।
जरूरी
ऐसा डिस्पोजल ऑफ रिप्रेजेंटेशन में
नहीं,
थोड़ा सा
जरूरी
एरर
है।
हो जाता है, बहुत सारी चीजें वो छोड़ देते हैं
जी।
लिखने से, इसीलिए
इसीलिए
इस
हम-
तरह से हम नहीं करना चाहिए।
हम सिर्फ असिस्ट कर रहे हैं जो कि कौन सा
पैरा 37 बताइए कौन सा पैरा 37?
पेज 78 में जो देखा जाए
अभी 78 तक तो हम पहुंचे ही नहीं।
तो पैरा 37 77 में
हाँ ठीक है। इसमें पैरा 37 मत लिखिए। The learned counsel submits that the matter was challenged before the Honorable Supreme Court in Civil Appeal number 7364 of 2018, and the civil appeal has been dismissed by judgment dated 5/3/2022. The learned counsel in particular has referred to para 37 of the said judgment passed by the Honorable Supreme Court, and submits that the present case is squarely covered by the judgment passed by the Honorable Supreme Court and is binding upon this court. It is further case of the petitioner that a number of writ petitions have been filed in the present case, including WPS number 4258 of 2016. इसको लगाए हैं 4258 of 2016. including 4258 of 2016 and other analogous cases in which the certain decision taken by the respondents has been quashed and set aside. And the matter has been remitted back to the respondents for reconsideration. The Learned Counsel has also submitted that. Further orders have been passed by this court in WPS number 1900 of 2021 and also in WPS number 596 of 2023, wherein the matter has been remitted to the respondent authority for fresh consideration. For consideration of the grievance of the petitioner by referring to the judgment passed by Honorable Patna High Court and Honorable Supreme Court. The Learned Counsel submits that similar order may be passed in this case and the matter be remitted to respondent number 2 to consider the grievance and pass appropriate orders. The Learned Counsel appearing on behalf of the respondents has submitted that a counter affidavit has been filed in the present case opposing the prayer of the petitioner and has submitted that the judgments passed by the Honorable Patna High Court, which has been affirmed by the Honorable Supreme Court, is based on certain policy decisions which has been taken by the state of Bihar after bifurcation. He submits that the policy of the state of Jharkhand is required to be taken into consideration and it has to be examined as to whether the case of the petitioners are covered by the judgments passed by Honorable Patna High Court and by the Honorable Supreme Court. He has also submitted that if the case is squarely covered by the judgment passed by the Honorable Supreme Court, there is no reason that the respondent will take a different view, but all the points should be kept open, right?
Right.
The Learned Counsel appearing on behalf of the petitioner in response has submitted that the stand taken by the respondents in the counter affidavit is misconceived and the provision of law which has been referred to in the counter affidavit is not applicable and a detailed rejoinder in this respect has been filed. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that different orders have been passed by this court, but no adverse order with regard to the petitioners or any similarly situated persons has been placed on record by both the parties. Accordingly, this court finds that every aspect of the matter, including the applicability of the judgment passed by Honorable Patna High Court as well as the Honorable Supreme Court, is required to be examined with respect to the facts of each case at the first instance by respondent number 2. Accordingly, the state petition is disposed of and asking the petitioner to approach respondent number 2 by filing a detailed representation who shall look into the grievance of the petitioner and grievance of the petitioner in the light of the judgment passed by Honorable Patna High Court, which has been affirmed by Honorable Supreme Court, and also with regard to the policy of the state of Jharkhand and any decision and / guidelines which has been taken by the state of Jharkhand. The recent order be passed after granting an opportunity of hearing to a representative of the petitioner and the reasoned order be communicated to the petitioner through speed post. The deed will be done by respondent number 2 within a period of 2 months from the date of communication of this order. देख लीजिए बढ़िया से अच्छे से.
I was referring only para 37 why? Because the Honorable Supreme Court laid down the law.
Yeah.
And it has been said that the state is bound to follow.
That's right.
That is the reason
I have referred to para 37.
Yes,
Quote
sir.
कर दें.
I
I have referred to para 37.
I appreciate it.
आपका कोई चीज हम छोड़ेंगे थोड़ी लिखने
उनका
से.
भी नहीं छोड़ना है मेरा.
जो आपको मिलना है वो आपको जितना जल्दी हो सके मिलना चाहिए. ठीक है.
Item 13.
देखिए एक चीज और लिखिए. If the petitioners are found entitled to any monetary benefit out of the recent order, the respondent number 2 shall take appropriate steps such that the monetary benefit is remitted to the petitioner within a period of 6 months from the date of the recent order. कंटेम्प्ट में नहीं आना चाहिए मेरे पास. मेरे पास तब आएगा भी नहीं कंटेम्प्ट. आई थिंक
उसको ही कैसे रोके?
नहीं आप डिसाइड कर लीजिए. देना है दीजिए, जो करना है.
ऑलरेडी एक मैटर में करके फाइल हो चुका है.
मुझे दूसरा वाले को दिखाया है.
डिसीजन हुआ है किसी में?
दैट माय लॉर्ड हैव टू
Not yet.
नहीं अभी तक नहीं हुआ.
No decision.
सी जब बहुत ज़्यादा लोगों का इन्वॉल्वमेंट होता है, थोड़ा सा इंडिकेशन दे देने से हमको लगता है थोड़ा सुविधा होता है लोगों को ऑर्डर करने में. बिकॉज दे आर नॉट दे आर टेक्निकली साउंड सो फार एज फाइनेंस एक्सेट्रा इज कंसर्न. लॉ उन लोगों को थोड़ा सा, ये लोग लॉ ऑफिसर क्या करेंगे?
Same order in all three.
उसमें सिर्फ पैरा बदल जाएगा.
पैरा
पैरा मैंने जो डिटेल्स दिए.
Vote.
हाँ वो बदल जाएगा. ये तीनों ऑर्डर्स आप ही करेंगे.
Item 13. WPS 786 of 2023.
directed to file counter affidavit, but file counter affidavit, they have not.
नहीं, इसमें ऑनरेबल चांसलर को वही बताएंगे कि इसमें क्या होना था. Because you say that the
Yes.
panel was not
Yes, Lord.
confirmed, और जो भी उनका है, जो भी अपना स्टैंड है वो बताएं.
ठीक है मैडम.
ठीक है.
फर्दर इन लोगों को भी टाइम दे दीजिए काउंटर फाइल करने का, और हम अभी अब रीडिंग से बना दें.
WPS number 786 of 2023. Counsel for the parties are present. In spite of order dated 17/2/2023, counter affidavit has not been filed by the state. Then a counsel for the petition, the respondent seeks. How much time?
State has filed.
State has filed. Okay.
State has filed and said that JPSC and universities are necessary to do.
नहीं, counter affidavit has been filed by the state, but no counter affidavit has been filed by respondent number 325. Right? University की तरफ से कौन है? You also file counter. Counsel for the respondent university and JPSC pray for and are granted time till 15th of May to seek instructions to file the counter affidavit. This court is of the view that for the ends of justice, let the office of chancellor be made party respondent in this case.
Respondent number 6.
उसका जरा डिटेल दे दीजिए,
हाँ.
है ना? तो उसी हिसाब से ऑर्डर ड्रॉ होगा.
हाँ.
The petitioner is directed to carry out the necessary addition in the cause title in writing during the course of the day. Respond number 6 बने.
Yeah. And I will serve 2 copies to Mr. Prasad.
Counsel for the petitioner is directed to serve 2 copies of the petition to Mr. Prashant Vanda, who is the retained counsel
Yes, sir.
for the Honorable Chancellor. The needful be done by the counsel for the petitioner by tomorrow.
No.
Let counter affidavit be filed by newly added respondent number 6 by 15th of May. The rejoinder, if any, by 12th of June, post on 26th of June. Petition में है ये, under the same.
Item 14, WPS 899 of 2023.
The last order can issue that the direction is given to the respondent for filing counter affidavit with regard to their amendments for consideration of the case of the petitioner. They have stated in the counter affidavit the post have been surrendered after 3 years. And that is the statement made in paragraph the recent paragraph 7. And subsequently, it is stated that in light of the order passed by this honorable court in LPA, they have taken initiative for further counseling, and the counseling and the recent last week, I got the letter that the date is fixed on 25th of this month for that is for conducting of the counseling in the district of Sahibganj. So in light of that, maybe disposed of that is the petitioner.
Provided you are entitled to be called for counselling in terms of that order. यही चाहिए.
बस
509 भी चाहिए. 5 कौन सा 510 दो ऑर्डर पास हुआ.
2 ऑर्डर पास है.
510 भी एक ऑर्डर है और एक 203 LPA 203 है ना.
203
of 2022
2020.
and 510 of 2023.
Yes. But my case is that I was they could not consider my case due to overage.
उसके अनुसार जो होगा सो हो जाएगा.
My lord.
उसको लिखवा देंगे तो जो हमारे लिए अच्छा है.
उसके बियॉन्ड नहीं लिखा सकते. जो उसमें है आपका एंटाइटलमेंट होगा तो आपको बुलाएंगे, आपका एंटाइटलमेंट नहीं होगा तो आपको नहीं बुलाएंगे. किसी भी इंडिविजुअल केस के लिए इंडिविजुअल ऑर्डर नहीं कर सकते. मास काउंसलिंग है ना.
मास
तो फिर इंडिविजुअल ऑर्डर्स हम लोग कैसे.
हमको तो ये लोग बुलाएंगे फिर काउंसलिंग में हमारा ओवरहेज नहीं. बट
जो भी आपका जो भी एंटाइटलमेंट होगा उसी अनुसार.
यहाँ पर डिफर कर रहा हूँ कि हमारा ओवरहेज पर हमको फिर काउंसलिंग में रोक दी, उसके बाद हमको आगे नहीं बढ़ने दी. तो अब तो इनको हमको बुलाएंगे नहीं जब तक मैटर डिसाइड नहीं होता है कि हम ओवरहेज नहीं थे.
तो फिर आप कैसे बोल रहे हैं कि सेम ऑर्डर कर दीजिए.
डिफरेंट ऑर्डर्स नहीं करेंगे. उन्हीं का स्टेटमेंट था कि हम कंसीडर करने की बात लोग कहे थे लास्ट टाइम.
तो अगर एज पर दोज ऑर्डर्स इफ यू आर एंटाइटल्ड यू विल बी कॉल्ड. आप बोलेंगे तो हम उस टर्म्स में ऑर्डर कर देंगे. नहीं तो 25 का काउंसलिंग हो जाएगा, उसके बाद कोई काउंसलिंग नहीं. फिर उसके बाद केस ही आपका इंफ्रक्चुअस. क्योंकि देयर इज ओनली वन काउंसलिंग व्हिच इज टू बी हेल्ड. WPS number 899 of 2023. The learned counsel for the parties are present. The learned counsel for the respondents, the learned counsel for the petitioner has submitted that a counter affidavit has been filed in the present case, indicating that upon expiry of 3 years, all the posts were surrendered. कहाँ है पैराग्राफ?
पेज 7 पेज 8 पैराग्राफ 7.
And that no seat is available for appointment of assistant teachers, and therefore considering the claim of the petitioner does not arise. However, he submits that
page 40.
yes, he has submitted that the respondents have also referred to judgment passed by this court in LPA number 203 of 2022 dated 15/9/2023, whereby one more counselling is to be done. कहाँ लिख के इनको बुलाएंगे?
यह
Para number?
पैराग्राफ इसमें है पैराग्राफ 10
Para?
10
10. Page number?
पेज नंबर 40.
The learned counsel submits that if the petitioner is found entitled for counseling in terms of the aforesaid judgment passed by this court, then the learned counsel submits that this petition be also disposed of in terms of LPA number 203 of 2022, and if the petitioner is found entitled for counseling, then the petitioner be also called for by the respondents. यही है? ये 510 आप देखे हैं? इनको जरा
जीरो
दीजिए।
का कॉपी लगाए
कहाँ लगाए हैं 510 का कॉपी?
टू जीरो थ्री LPA
203 के अलावे
203 है पैरा टीचर्स वाला जो 510 का ऑर्डर। ये सब आप लोग के पास एक कॉपी, आप जानते हैं पिटिशनर को कुछ पता ही नहीं होता।
उसकी कॉपी
आपको मालूम है 510 में ऑर्डर हुआ है? आपको भी नहीं मालूम?
नहीं
बहुत खुशी की बात है। वहाँ पे खुल लेना।
204
इतना लंबा ऑर्डर, एक कॉपी रखना चाहिए आप लोग को। आपको पता है कि काउंसिल्स को कुछ नहीं पता, ना रिस्पोंडेंट को पता होता है ना पिटिशनर को पता होता है। कॉन्फ्लिक्टिंग ऑर्डर्स कराते रहते हैं हर कोर्ट से। In connection with the same counseling to be conducted pursuant to LPA number 203 of 2022, further orders have been passed by this court in LPA number 510 of 2023 and other analogous cases. Disposed of on 31st of January 2024. The learned counsel for the respondents has also submitted that if the petitioner is found entitled to participate for counseling in terms of the aforesaid 2 LPS, then only there is a question, or then only he can be called for counseling. Okay? At this, counsel for the petitioner has submitted that the petition be disposed of in terms of the aforesaid 2 LPS. After hearing the counsel for the parties and considering the fact that one more counsel is required, he has also submitted that for the district of Sahibganj, the date of counseling has been fixed on 25th of April 2024. After hearing the counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that one more counseling in connection with the selection process is scheduled to be held in terms of judgment passed in LPA number 203 of 2022, read with LPA number 510 of 2023 and other analogous cases, wherein following directions were issued. हम लोगों ने orders किए हैं, उसमें है this writ petition is also disposed of in terms of the aforesaid two LPs.
Item 15, WPS 957 of 2023.
Who is for the petitioner?
Yes, Your Lordship.
Let's say the petitioner has been given the promotion.
He has been given the
Given
promotion.
the promotion.
The case has
We have
become
filed,
infructuous.
we have filed the supplementary counter.
The case has become infructuous. The case has become infructuous.
Yes, let's see. He has given promotion with effect of 2011-2020. He was claiming for the same year.
Where is the statement?
The statement,
The case has become infructuous, Mr. Gill. The learned counsel for the parties are present. This writ petition has been filed for the following reason. The learned counsel for the respondents submit that the petitioner has been granted the promotion and therefore the present case has become infructuous. He submits that this fact has been brought on record
Annexure A.
in the
Annexure A, supplementary
in
counter.
the supplementary counter affidavit,
Annexure A.
annexure A, dated 8/4/2024. Annexure A dated date भी आपका कट गया, has been brought on record by filing supplementary counter affidavit dated 9/4/2024. At this, counsel for the petitioner submits that the present writ petition has become infructuous. Accordingly, it is disposed of as such. 19/3/2024. Accordingly, this writ petition is disposed of as such.
Item 16, WPS 987 of 2023.
As a deadline outside your issue, I seek some time for finding out the rejoinder. The rejoinder is ready, since petition is under regularization, it is not withdrawn.
The learned counsel for the parties are present. Counsel for the petitioner seeks adjournment to file rejoinder to the counter affidavit. Post this case on 29th of July 24. Let the rejoinder be filed latest by 19th of July. Under the heading for final disposal.
Item 17, WPS 1004 of 2023.
This honorable regulation, this matter pertains to reinstatement and regularization. Your Ladyship, this petitioner has worked for Kendra Vidya KVK, Kendra, which which comes under Birsa Agricultural University. And he has served from 2008 to 2020, as per record with them. And without any notice, without any termination order, your leadership, he has been disengaged. Your leadership, for a moment, order dated 25th of July 2023, may we see order number 6.
You have filed your counter affidavit.
They have filed. They have filed.
You have any scheme for regularization?
Yes.
They are entitled or not entitled, as per your counter affidavit?
No, actually, before filing a first writ petition, there were earlier also he has filed a writ petition. There were 28 petitioners, and before that, my lord, he was not working because after completion of 6 months, twice or thrice, 6 months time were extended. But however, he worked more than 10 years, my lord. But my lord, when the first writ petition was filed for regulation of 28 petitioners, his name was the last name. Item 28, my lord, his name was there.
लास्ट या फर्स्ट नेम से क्या फर्क पड़ता है?
फर्क पड़ता है ना, हम ये कह रहे हैं कि इसलिए कि वो that time he was not working, but the application was filed along with others for regulation of service. That although he was not working on that.
On that day also he was not working.
That day also he was not working.
2019 he was not working.
He was not working.
He
19 no, Melody 19 Melody.
He was working. Page
I
number
think
27 of the recent order.
because the direction was given. If he is not paid the salary, then his salary should be paid. And before that, my lord, he was not working, and due to shortage of post, and he was a jeep driver. I mean, the jeep was not available for last 10 years in KVK Dumka, somewhere where he was working. So he was adjusted against some other work, and however the university from the internal source managed to pay daily wages on contractual basis some salary. But he was the employee of KVK.
Do you have a sanctioned post for driver?
We had the post, no, KVK is the scheme. Krishi Vigyan, the entire work is under the ICR, Indian Council of Agriculture Research.
This is under a scheme.
Under the scheme he was
so
working.
They will regularize, they want regularization as what?
Regulation there was no question about regulation because the ICR, whatever the post is given, all posts are under the scheme.
That's right.
So, the direction finally was given in that petition to consider, and about him it was written that if the salary is due, then the salary should be given. Then the university passed a reason order, which
Where is the direction of this court?
Yeah, direction of the Honorable Court is below page Annex of 7, page number 38.
Yes, please.
Annex of 10 is the reason order.
No, first let us see the direction. Para number 7. There was earlier order of 4829 of 2017. Where is that order?
This regulation.
4829 of 2017.
This person has been regularized.
Where is that order?
That is at Annex 6, page 36.
Madan Mohan Mishra case. It is some other.
Yes. But similarly situated, is that
Not
so?
at all.
Just a moment. You first place Annexure 6.
Yes, your leadership in this case, same matter was there, regularization matter, and admittedly, your leadership.
You just place it. You place the order.
Should I
place
read
36.
the entire order?
Para 2 facts.
Para 2. The factual exposition as has been delineated in the writ petition is that the petitioner was appointed on casual basis and working under respondent since 10/6/1989 to 31/8/2004 as an accountant in district Krishi Gyan Kendra Lohardaga against the vacant post of office superintendent accountant and working till date, which shows that petitioner is working against sanction and vacant post. Further, the petitioner was appointed as office superintendent cum accountant with effect from 1/9/2004 on contractual basis under the respondent authorities and is working at Lohardaga. Time and again service of the petitioner has been extended, and recently he has been extended only for 6 months, that is 1/6/2017 to 30/9/2017, and the petitioner is still working. The petitioner made several representations for consideration of this case for regularization, but the same has not been considered till date. Neither any order to that effect has been passed, and hence this writ petition, present writ petition. Your Leadership, and the operating portion of the judgment is at para 6.
Yes.
Be that as it may, having gone through the rival summations of the parties, this court is of the considered view that the respondents have not passed any order regarding consideration for regularization of the petitioner, though he is working since 1989 till date or from 2004. Admittedly, from the perusal of the records, it transpires that the petitioner was not a backdoor appointee. He was offered a letter of appointment by the director himself and also by the vice chancellor. It is also apparent that the petitioner is getting full salary for the post he is holding. In view of the above premises, I direct the vice chancellor to consider the case of the petitioner for regularization in view of the celebrated judgments of the Honorable Apex Court rendered in the case of State of Karnataka versus Uma Devi.
That's right, we have seen. Then what happened?
Thereafter, Your Ladyship.
He has been regularized?
He has been
Where is the
regularized.
order of regularization?
I can file a supplementary, Your Ladyship, for bringing on record the
There is
order.
a direct judgment of the Honorable Supreme Court in 2023 that there is no question of regularization of contractual employee, even if he continues for years together.
Indeed, but in this case, Your Ladyship, he has been working at this vacant and sanctioned
No.
And
He was subsequently appointed as a contractual employee. Therefore, I have my doubts whether he has been regularized. He has been regularized?
yes, yes.
But actually,
कुछ नहीं पता दोनों को.
after filing secondary petition, again the action was given. Madan
this-
Mohan Mishra. Madan Mohan.
For Madan Mohan Mishra was a petitioner in the secondary petition also.
He filed secondary petition.
Where is that? Where is the secondary petition?
Actually, secondary
कुछ भी
petition.
नहीं पता होता है.
It was a petitioners to bring the record if anything.
आपको नहीं लाना चाहिए क्या?
आपको तो करना चाहिए था.
अगर एक को भी आप कर दिए तो सबको करना पड़ेगा ना?
It is not similarly situated. My lord, he was working for last 35 years. Moreover, he was regularly working, not extension of 6 months. This petitioner, my lord, extended thrice and 4 times, 6 months extension. And finally, my lord, in 2020 March, thereafter he was not working. And there was no post, but in spite of writing request letter to the...
Anyways, इसका तो पता नहीं क्या हुआ. It's not there on record.
He has been regularized, Your
We do
Ladyship.
not know.
As
We
per
do
the-
not know. We will go by the judgment of the Honorable Supreme Court.
So I bring on
We will.
There are several
We
judgments.
will not pass any order which is contrary to
Until I
the
may be
view of the
granted to
Honorable
me, I'll
Supreme
bring on record the appointment letter of
How
Madan
does
Mohan.
that make a difference?
And moreover, this writ petition earlier which we have referred, one of the petition he has been regularized. The petition
Who has
number
been
one-
regularized?
Petition number 1, Shubhankar Kumar. Annexure
Where is
number-
the order of his regularization?
That those orders have been passed subsequent to filing of this writ petition, Your Ladyship. Therefore, I am asking a daytime. I will bring that on record. This case will be kept on Wednesday.
You can't seek adjournments like this after commencing arguments, right?
Indeed,
These
Your
are
Ladyship.
these are essential
Apology.
things. If you are claiming parity, you should have brought it on record. You
Indeed.
should have known whether he has been regularized or not.
Indeed.
The moment the court puts a question to you, you seek adjournment.
Since one order of the Honorable Court is there, Your Ladyship, order number 6, wherein the specific direction was been given to the respondent to bring on record the scheme as well as the disengagement order. That has not been brought till date. If they will bring that on record, I'll file a rejoinder in complete manner, exhaustive rejoinder to this.
If they do not file, so a writ of mandamus is to be issued. You have to make out your own case, always.
Indeed, but that
By
was the-
default, you cannot have a decree.
It was the order of the Honorable Court there for Your Ladyship.
आप नहीं लेके आए हैं, नहीं अप्लाई किया.
But there is no scheme of regularization.
So
in
that
the-
also you have to bring on record that there is no scheme for regularization.
I have mentioned minimum servant affidavit, servant accountant.
Order number 6 may be seen for a moment, Your Ladyship.
Where is the scheme for regularization? Without a scheme, can any regularization be directed like this?
University does
Your
not have any.
Ladyship, annexure number
They have filed their affidavit. How do you say that they are not?
annexure number 4 may be seen for a moment, 29. This is a letter issued by the BIS Agriculture University, wherein they have said that they'll adopt the scheme of the state of Jharkhand, and the same has been circulated to all the KVKs. page number 29. This is a letter of the Sahayak Nirdeshak Prashashan.
So your case for regularization is as per the scheme of regularization. Okay. Are you covered by that scheme?
Indeed, Your Ladyship.
What is the period you have remained?
I have worked from 2008 till 2020 as per then, March 2020. And my letter for appointment is at edition number 1.
What is the minimum period of work?
10 years.
10 years from commencing from?
Commencing from for state of Jharkhand, there is no as such time bar. That is as per state of Karnataka versus Uma Devi. It was cut-off date was 2006. For state of Jharkhand, relaxation was there since state of Jharkhand was being created in the year 2000 itself. Therefore, 10 years could not be completed by the employees of state of Jharkhand, Your Ladyship. Thereafter, Narendra Tiwari judgment came into existence, and as per Narendra Tiwari, till 2016, Your Ladyship.
Till 2016.
10 years. It is, Your Ladyship.
So you have completed 10 years till 2016?
I have completed 10 years on 80.
So it is a continuing process that anybody, I don't know.
It's a continuing process, and they have already regularized one Shubhankar, since similarly situated. And Madan Mohan Mishra, Your Ladyship, they have given all the employees pay revisions, Your Ladyship. And Madan Mohan name is there in the same list of pay revision, wherein petitioner's name is also there. I can show that through my annexures, Your Ladyship.
You shift from one point to another. Why do you need to shift? The question of your
Parity for the
You
reason.
see, if you are coming under a scheme for regularization, we will examine your case for that scheme
Indeed.
and nothing more.
Certainly.
Right?
But
So
before
you
that,
have to first satisfy us, so far as the scheme is concerned, that you are covered by that scheme.
indeed.
Sir, how do you say that the scheme is not applicable to you? And there is no scheme for
Now the question
regularization?
whether Your Lordship will consider the question of mobilization or the question of reinstatement. Because he is not working, and she has also filed application for reinstatement this petition. First, until
You are seeking
the question
reinstatement
of
also?
reinstatement,
Reinstatement. Because without any order, Your Ladyship, I've worked for
for
altogether
6
12
months,
years.
thrice Modi service was extended. And Your Lordship see the first appointment letter, that is not appointment letter which my friends say that it is appointment letter.
Without any disengagement letter, Your Ladyship. That was the order of the Honorable Court. That bring on record
There
the
is no question
disengagement
of
letter if you have disengaged.
the termination
Even for
letter.
the contractual employees, Your Ladyship, if the respondents are state exchequers, Your Ladyship, they have to comply the rules. They have to give a notice, they have to give a termination order. They have taken work altogether for 12 years.
If somebody is continuously working, then we don't need regulation.
It's not entitled for even for the disengagement letter. And even of the order of the court is
Beyond the records of the case.
I'll bring on.
No lectures, and you can assume that the court does not know.
Indeed.
Right? You have to bring the scheme for regularization on record, which is not there. 2019 scheme, 2015 scheme, whatever.
I'll bring on
Right.
record all the judgments and all the orders. A week time will be permitted.
Counsel for the parties are present. Counsel for the petitioners. Petitioners has advanced arguments by referring to certain facts which are not on record. Counsel for the petitioner prays for and is granted time till 22nd April 2024 to file a supplementary affidavit bringing on record the materials which she seeks to rely upon, and in particular the fact regarding regularization of Madan Mohan Mishra, who was a petitioner in WPS number 4829 of 2017. Subhankar Kumar का तो impugned order में लिखा, it is mentioned in the impugned order itself.
But I'll bring on record the
The-
appointment letter.
You bring on record whatever you want to. Pose this case for further hearing on 23rd April.
Your Ladyship, today is 22nd.
Oh, sorry. कब तक? I have given you time till 29th
And then 30th.
and 30th.
Mashallah.
Item 18, WPS 1088 of 2023.
In this case, so far, NCTE is concerned about directed file counter, I have file counter.
University as NCTE. What is your response?
My study was almost identical matter had been decided by this one court. For that judgment, I have already next matter, the page 17 versus C matter. Petitioner counsel is not again.
It has been decided in favor of the petitioner.
No, madam.
Where is that? Annexure?
Annexes,
Page 17?
madam, this one, page 17.
Diploma in education.
Yes. A special course means then computational requirement of a special BA, a special course. That is 1 year course. And here in requirement is BA 2 years course. That is only important thing. And the regulation 2014 has come out at that time. So far advertisement is concerned, that is 2016. That will applicable. And that is the reason, my lord.
WPS number 1088 of 2023. Nobody appears on behalf of the petitioner. The learned counsel for the NCTE, Mr. Sunil Kumar, has submitted that the case of the petitioner is squarely covered against the petitioner by virtue of order dated 29/2023 passed in WPS number 3932 of 2016 as annexed with the supplementary counter affidavit filed on behalf of respondent file. In order to give one more chance to the petitioner for this case tomorrow. Mr. नंदा को कम्युनिकेट कर दीजिए, आए होंगे वो कोर्ट रोज आते हैं.
Item 19, WPS 1381 of 2023.
फिर ये पर शॉर्ट पास होगा.
In this case, my lord, we have filed counter, they have filed rejoinder.
What few cases?
So for final disposal, we can.
Who will argue this case?
Mr. Adanu बनेंगे.
तो बहुत बिजी है, उनको कहाँ टाइम मिलेगा आज?
Few cases.
सिनॉप्सिस नोट्स बनाए हैं उसके बिना
नहीं, बना हुआ है.
कहाँ है? फाइल करिए, उनको भी कॉपी दीजिए. आने दीजिए. मिस्टर बैनर्जी का कोई भी केस एक दिन में खत्म नहीं होगा. We'll just find it out वो क्या बहस करेंगे.
Item 20, WPS 1395 of 2023.
This matter, my lord, I will file rejoinder.
WPS number 1395 of 23, counsel for the parties are present. Counsel for the petitioner seeks adjournment to file a rejoinder in this case. Close this case on 29th of July 24. Let the rejoinder be filed latest by 22nd of July 2024. Failing which no further adjournment will be granted for this purpose. Parties to file, synopsis, list of dates, etc. जो है final. क्या matter है?
With regard to grant of pay scale, my lords, it was withheld on the ground of suspension, and thereafter he was departmentally proceeded, and the criminal proceeding was also.
Final disposal में डालेंगे 29 July. You file your list of dates, etc.
Yes.
Item 21, WPS 1754 of 2023.
This matter is covered by the recent judgment of the Supreme Court, where our full bench decision was upturned. But the petitioner was in service and had applied for appointment on a limited examination of the post of deputy collector. Admittedly, when the petitioner was in
The pleadings are complete.
yes.
Just a moment. Which judgment has been set aside by Honorable Supreme Court?
Pankaj Kumar judgment, my lord, where the full bench decision of our court, my lord, was reversed by the Honorable Supreme Court, where it has been clearly held, taking in aid of section 72 and 73 of the Bihar Reorganization Act, that if a person who was already working, maybe a original resident of the state of Bihar, but was working in the erstwhile state of Bihar, that is the undivided state of Bihar, and was belonging to a reserve category, then in the limited departmental examinations, he cannot be denied the benefit of reservation.
When he's already
Working as a scheduled caste candidate prior to his appointment, prior to the creation of the state of Jharkhand. Wherever he is born, wherever he is not born, that doesn't make any difference.
That's all. Where is
Yes.
this is the judgment?
Yes, judgment, my lord, it was annexed in the petition also, but I have given in the separate compilation, page 128.
Let us see the facts of this.
Yes, facts of the case is very simple, my lord. If your lordship may take the list of dates.
My lord, it may be taken your lordship on any other date, your lordship.
Any other date you have given it
Because
to
your lordship, I am not ready, your lordship, and my lord, what he is saying that in terms of the order passed by the Honorable Supreme Court, he is not required to submit the caste certificate. That is his
for
contention.
promotion.
For considering his case for extension of the benefit of reservation. That is his.
Fresh caste certificate need not be required because he was already inducted in service under reserved category.
My lord, that is in relation to those candidates, your lordship, who were originally have been finally allocated the Jharkhand cadre from Bihar, your lordship.
Scheduled caste, my lord, and he was in Jharkhand
Scheduled caste by virtue of presidential order.
order, yes.
And then
My lord, that is not the question, your lordship. Subject to
If
your
my friend wants
lordship.
to argue, I am ready, my lord.
No,
He may
no.
not prejudice by saying taking
no,
lead in
he
argument.
will. Let's figure it out.
Yes.
Let's figure it out. What is the issue, and then if he wants
and
adjournment.
what will be my contention? My lord, the petitioner was born in Hazaribagh district, your lordship. So far, the case decided by the Honorable Supreme Court is concerned, your lordship. Those candidates were born in the Bihar, they were working in Bihar, and after creation of the state of Jharkhand, they were allocated Jharkhand cadre. Then, your lordship, the question came that whether they are entitled to get benefit of reservation in the services or not. The contention of the state was this, that since it is a fresh appointment and as such they will be not getting the benefit of reservation in the services. My lord, the matter
Fresh appointment by way of promotion.
by way of promotion. Thereafter, your lordship, the writ was allowed. State filed the appeal. Appeal was the order passed by the Honorable Lead Court was dismissed, your law set aside, and the appeal was allowed. Then the matter went to the Supreme Court. The Honorable Supreme Court had been pleased to hold, your lordship, that since they have been allocated Jharkhand cadre, and as such the protection is there, and as such they are also entitled to get benefit of reservation in the appointment in the state of Jharkhand. That is the sub and substance of the Honorable Supreme Court order.
So how does it not apply to this case?
In this case, it is not applied because in terms of the advertisement of the JPSC, your lordship, he submitted the caste certificate, but that is not in terms of the forma indicated in the notice. And what is his contention? That I was not aware that any other
He
phrase.
was already in service.
May I just clarify what was the law laid down by the Supreme Court?
Service candidates are also required to submit. We are also required to submit the caste because, your lordship, we have issued advertisement.
This is appointment by promotion.
This is appointment by promotion.
My lord, the case before the Honorable Supreme Court was exactly the same. My lord, the person who applied for a limited departmental examination, which was appointment by way of promotion or can be said to be fresh appointment, either way it may be treated. He was working as an assistant teacher appointed prior to this creation of the state of Jharkhand, and he was working within the territories of the state of Jharkhand, though he was a permanent resident of state of Bihar. In that case, my lord, he was not allowed the benefit of reservation on the ground that you are a permanent resident of the state of Bihar. The Honorable Single Judge allowed it, taking the judgments of Gijoria and other judgments, my lord. The matter was before the division bench, it was referred to the full bench because there were conflicting decisions. Then the full bench, my lord, in a 2:1 judgment, my lord, held that the benefit cannot be extended to those who are permanent residents of the state of Bihar. Now, my lord, in that case, there were two sets of petitioners before the full bench. One set of petitioner was the person who was appointed as an assistant teacher and had applied for limited departmental examination. Another set of persons were the fresh recruitment, nothing to do with the appointment, and they were appointed on the post of inspector or sub-inspectors like that, but they had the permanent resident of the state of Bihar. The Supreme Court decided the ratio that so far as the persons who are already appointed and working, they will be extended the benefit of the protection of service under section, irrespective of the
Must be Bihar Reorganization Act.
Bihar Reorganization Act section 72 and 73 was interpreted. It was argued before the full bench, but the full bench had repelled 72 and 73 by saying that it will be treated to be a complete new appointment. You can't take the benefit of 72 and 73. The Honorable Supreme Court said that no, so far as in-service employees are concerned, 72 and 73 protects
They
them.
cannot be they cannot be put to a disadvantageous
Advantage than what they
position by
were prior
virtue
to
of bifurcation.
Bifurcation. And then, my lord, so far as the sub-inspectors are concerned, the Honorable Supreme Court extended the powers under Article 142, and even to them they allowed the
So we are not concerned.
we are
with
not
them.
concerned with sub-inspector. We are concerned with the ratio of the judgment.
आपको
Incidentally,
कब
my lord, I
करना
had the
है?
privilege to argue on all the three stages.
But after 2 weeks, any date.
My lord, it's
2
fairly
weeks
covered
अब
order.
तो सुन लिया अब आप बस जल्दी से डेट बताइए छुट्टी के बाद नहीं हो सकता है
अच्छा ठीक
छुट्टी
है
के
ठीक
बाद
है
अगर लास्ट डे भी रखिएगा ना तो 4:30-5 बजे तक हम सुनेंगे इसलिए सोच समझ के
I am already
Yes.
assisting your lordship. And when your lordship is hearing, then it is our duty to
अब हम
assist your
सुन
lordship.
लिए अब
Whether it
हमको
is
पेशेंस नहीं है अब आप हमको बताइए
जी,
कब करिएगा
13 तारीख को रख दीजिए,
13
13 या 14 subject your lordship for me.
नहीं हमको कोई दिक्कत नहीं है आप अपना डेट सुविधा अपना देखिए Learned counsel for the parties are present. The learned counsel for the petitioner submits that the petitioner had participated in limited competitive examination and was inducted in service as a scheduled caste candidate prior to bifurcation of the state of Jharkhand. He submits that his candidature cannot be rejected on the ground that he originally belongs to state of Bihar. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court in the case of Pankaj Kumar versus State of Jharkhand and others reported in 2021 SCC Online SC 616. The learned counsel for the respondents has submitted that the ratio of the state judgment does not apply to the present case. He submits that in the present case, the appointment is by promotion, which is a fresh appointment, and the petitioner was required to furnish his caste certificate in terms of the advertisement.
And subsequent notification.
And also
subsequent corrigendum, Your Lordship.
Subsequent.
Even when there was no requirement, my lord, of the caste certificate, they
read with the corrigendum.
corrigendum.
Caste certificate में क्या इनका? Did you submit the caste certificate? Or
He
you
submitted,
did not?
but his contention.
Just. Did you submit the caste certificate?
Original advertisement, there was no caste certificate requirement. It was only the recommendation from the department. They subsequently this was cancelled twice. Pursuant to the orders of this High Court, my lord, again they had filled up the backlog vacancy. Then they issued a corrigendum saying that you submit a fresh caste certificate. I submitted it, but since in my caste certificate, my lord, the caste certificate will always be from Patna only, my lord.
Naturally.
So they said that it will not be valid.
This caste, whatever your caste,
It's both in the both states it is recognized. Tushar.
okay.
I'm
Both,
pleading-
I just want to know constitutionally that the presidential orders which are issued,
Yes.
with particularly with regard to scheduled caste candidates, persons, then the corresponding state is also mentioned in that notification. And I think there is one matter which has been referred to larger bench as to
That's coming up
whether
on 25th.
the caste under the presidential certificate, under the presidential order, a person belonging to scheduled caste in one state, whether he will be entitled for reservation under the same category in other state. I think this is the
That,
issue.
no, madam. That law has already been settled, Your
Just
Lordship.
एक second, रुकिए ना please.
In fact, our full bench decision, which was rendered, the earlier, which has been overturned by the Honorable Supreme Court, that decision went on this principle only. That since you are in Bihar, you were in Bihar, because that law is already settled, my lord. In the case of 1996, it is Mary Margaret case, that it has been settled that on migration from one state to another, whether you are of the same nomenclature of the caste, you will not get the benefit in the migrated state.
Okay, for ST or ST?
Both, ST and SC both. It is settled, my lord, that you will not get it on migration. Then came, my lord, another decision in 2006. It was in relation to bifurcation of the state of Maharashtra, Madhya Pradesh and Gujarat, where, my lord, it was held that the bifurcation is a complete different concept. And bifurcation will not amount to migration of a person.
That's right.
Merely because if he is falling in either of the two states, it cannot be said to be migrated. Sudhakar Vittal Rao judgment, my lord.
I think these judgments I have considered in one judgment.
My lord, that I have cited, Your Lordship, in old High Court, Your Lordship.
Old High Court. I remember that I have decided one case.
So that is not even a dispute here.
No, I just wanted to know because if I see my own judgment, I
will give it, my lord. Next day I will bring that judgment.
13th को रखते हैं, ठीक है?
And what is present before the full bench now, my lord, which is coming up on 25th, is another question where the JPSC has raised that although you may have the caste certificate, but since the caste certificate either was not in the requisite format which they wanted, or the caste certificate was submitted beyond the cutoff date of the advertisement, they had rejected the candidatures. So the matter has been referred to the full bench by saying that whether JPSC, 3-4 questions are framed, it basically whether the JPSC is entitled to do that or not.
That is not the issue here.
No, not the issue here. This issue is decided by the Supreme Court so far as this case is concerned.
That is his contention. My
At
submission
the
is
request of the learned counsel for the respondents, the matter is adjourned and is directed to be posted on 13th of May 2024 under the heading for final disposal. At 2:15, final disposal matters are taken up at 2:15. 13. कोई बात नहीं, 2 केस होगा, थोड़ा वेट कर लो.
Item 22, WPS 1756 of 2023.
वो मेरा जजमेंट हमको प्रोवाइड कर देंगे पहले.
हम तो दे देंगे पहले.
No, yeah, it when I read my judgment, it reflects that how I applied it and I don't remember, but I think I
We'll find it and give it to you.
Pass over. Few cases.
This is 21 of 2016. आपका काउंटर आ गया है?
Now, my counter is here.
क्या मैटर है इनका?
My lord, now they are saying, Your Lordship, that some of the candidates, my lord, what happened, Your Lordship? Matter went to the Honorable Supreme Court. It was decided, Your Lordship, that now the state-wise merit list is to be prepared, Your
That's
Lordship. Now their contention, they have not given name of any candidates, Your Lordship. That some of the candidates who have having no requisite caste certificate have been recommended for appointment. That is their contention.
Some of the candidates.
Some of the candidates. But they have not disclosed the names of such candidates.
Who will argue?
Vilas Kumar.
बुलाइए.
Few cases के बाद.
Okay, we'll pass it over.
But it is taken up in the first half, because in second half,
No, it will be taken up in first half. Passover matters are taken up in first half. 1 बजे आ जाइए.
in second half, Your Lordship, some matters with honorable division will be.
Item 23, WPS 1926 of 2023.
This is the matter, my lord, where petitioner has prayed for recalculation of the penal house rent, my lords, and refund of the excess amount calculated and deducted from the areas of salary of the petitioner, my lord, which was given to him in compliance of the order passed in earlier WPS number 2486 of 2010, which was decided on 13/12/2021. my
You are
lord.
still in occupation of the quarter?
No, I have left.
Recalculation करना.
Yes,
यहाँ पे कैसे होगा recalculation?
हो जाएगा as per legal provisions.
We are not here to go for accounting.
No, that
Who is the respondent?
housing board.
Housing board.
Yes.
आपका arbitration clause है ना? Agreement में?
Arbitration clause agreement में रहता है.
आप तो बस
लेकिन
उसी
यहाँ पे
में
ये he was allotted the employee quota, not under general.
He was an employer earlier, and they have deducted minors beyond the provisions of the
No,
law.
these things we are not going to recalculate. You get it done by the MD only. So
Then-
yes, a deed petition with recalculation we are not going to.
Then, my lords, the nothing will change, my lords. I just
What do you
demonstrate
say?
how it is illegal, the calculation of penal rate is illegal per se, as per the act and the rules provided therein itself, my lords.
What is your calculation?
My calculation is 12,12,000 rupees, my lords.
इतना आपने पेमेंट कर दिया?
मेरे से
जितना
direct-
आपके अनुसार कैलकुलेशन है उतना पेमेंट करके आइए
उससे
तभी
ज्यादा हमने ऑलरेडी हमसे डिडक्ट कर चुके हैं 5 लाख, वही तो
आपका
कार्य-
रिफंड क्लेम कर रहे हैं.
वो हम रिफंड क्लेम कर रहे हैं. They have calculated the
Where is-
house rent as per my lords, as per the act, my lord, not as per the area which is required to be calculated. Kindly have a perusal of, my lords, this 83A of the rules, my lords.
Where is it? Rules का?
Have a book, my lords.
I don't know.
Bihar State Housing Board Act.
Which area do you fall in?
Harm.
Harmo.
Yes.
Which rule 84?
83A, my lords.
That is section 83.
Section 83A. Space 43.
83A.
Yes.
Hmm.
May I read it? In addition to and without prejudice to the right available to the board under the provisions of this act or any other law or rule in force, the board shall be entitled to the following by way of damages. Any person who without any right or written permission of the board continue in possession of a building belonging to the board after termination of its tenancy in respect to it shall be liable to pay damages equal to 3 times the rent payable immediately before the termination of the tenancy. Second, any person who, without any right or written permission of the board, continue in possession of any land of the board after termination of tenancy in respect of it, shall be liable to pay damages at the rate of rupees 20 per 100 square meter of area of land per day until delivery of possession of the vacant land to the board. Any person who takes possession of any building, building or any land or building of the board without any right and written permission of the board or continue with such possession shall be liable to pay damages at the rate of rupees 20 per day for each 100 square meter of land area in case of land, and at the rate of rupees 50 per day for each 100 square meter of built up area of each floor of the building in case of building. So for 100 square meter of building, my lords, penal rent is required to be given at 50 rupees per day. So far my understanding is concerned, my lords. And the total area on which I was living is 26.91 meter, my lords. So for that, my lords, it amounts to 13 rupees 46 per paise per day. And the total days are, my lords, I have calculated.
So you are covered by clause 3?
Yes, yes.
Is that so that he is covered by clause 3 or you are referring to some other clause?
That section 83A is there, Lord. Subsection 1 kindly see. First is rent, second is damages. My learned friend is speaking with the damages, Lord. First is liable to pay penal rent. That is 3 times of the normal rent.
That I will calculate.
Number 1. Number 2 is damages. So that is in addition to the normal penal rent.
Is not damages.
Penal rent
is over and above damages.
In terms of the provision, 3 times of the rent and rupees 20 per 100 square. That is by way of damages.
I'm afraid my lord.
83A. Any person
Penal rent is always akin to damages only.
maybe, but provision is there, so you also kindly see the provision.
So
any
he has
person who without any right.
Please let me understand. According to him, he is to pay as in terms of rule 3, subsection 3.
Yeah.
According to you, which subsection is applicable? Mr. Sachin Kumar, according to you, which subsection is applicable?
83A 1 and 2.
1 and 2, okay.
Both. May I read for the
Just 1 and 2 and then 3. According to you, 1 and 2 is not applicable.
Yes. Region, may I explain the region?
He has got land or building?
Flat. Kindly see subsection
Just a
1.
foundational fact समझिए. Flat, right? Square feet area?
It is
1200 something.
26 meters है 26.91 square 26.91 square meter.
Square meter is the built up area, or it is the land area on which construction is made?
26.
Total area on which this building is situated.
Total area of the
Yes,
land.
they have claimed
Total
this
area
much
of the land.
Yes, total area of the building, my lords.
That is, yes.
So every calculation has to be done in terms of this 26.191 square meter.
Yes.
No problem on this. Okay. Now you tell us.
Yes. Kindly have a perusal of the supplementary affidavit, my lords, sir.
May I explain why 1 and 2 will apply?
Yes, you explain why 1 and 2.
Yes.
Like
One
both.
is any person who without any right or written permission of the board continues in possession of the building belonging to the board after termination of its tenancy in respect to it shall be liable to pay damages equal to 3 times of rent payable immediately before the termination of the tenancy. So
Just a moment. What was the
continues in possession.
he was your tenant?
He was
Employed.
He was allotted the flat for the period of his employment with the board,
Okay.
and he continued in the possession.
What is the date of his termination or retirement or whatever?
It is, my lords.
What is the date of his retirement and what is the date of his
Sometimes it
termination
might
of
be, yes.
tenancy?
Yes.
It is 1/2/2018.
Date of termination of tenancy?
The date on which I superannuated from the housing board employee.
1
1 to 2008.
2008. Just a moment. This is retirement.
Yes.
What is the date of termination of tenancy?
The date of his retirement,
From where do you get this?
only for the period of his employment, it was allotted.
Where is it? Do you want to say that on the day he retired, was in Vyavastha बांध के बाहर?
एक महीना, 15 दिन, 2 महीना.
There has to be a provision,
Yes.
no, that he has to vacate the quarter within 3 months or 4 months,
So you have to
or
letter-
maybe immediately, maybe 15 days.
Letter address not on the record.
नहीं है ना? Date of termination of tenancy कैसे आए? बताइए.
Date will be हमारे हिसाब से date of retirement होगा.
Okay, fine.
Normal 1 महीना, 2 महीना, 3 महीना हो सकता है, but it
Alright.
cannot be below the
Okay,
5 years or
so
6 years.
83A he continued.
Yes.
Thereafter, when did he vacate?
It got it evicted
30th of June 2020.
30 June 2022.
2022.
Yes.
All right. So thereafter you determined the
Yes.
amount.
From 1 to 2008 to 30th of June 2022.
1 to 2008 to
30th of June.
3622
22.
under subsection 1.
1 and 2 both.
So under 1
यहाँ तो एक ही में वन ही में किए हैं.
हाँ.
Damages लगाए नहीं हैं.
amount
Amount 1026 3 times इसका हो गया 3000 something आएगा for 173 months.
अच्छा, what is the figure?
1026 into 3.
26 into 3 into 76.
173 months.
173. All right.
3 क्यों नहीं अप्लाई करेगा? उसका रीजन है एनी पर्सन हु टेक्स पोजेशन ऑफ एनी लैंड और बिल्डिंग. सो 1 and 2 talks of below continuation. Initial entry was legal, but he continued in possession over the period of for the period he was authorized. And 3 talks of initial entry is itself illegal. So 3 will not apply.
Can you read 3?
Yes, any person who takes possession. वो 1 to दोनों पढ़ा जाएगा तो उसमें continued in possession लिखा हुआ है.
ठीक है.
यहाँ है any person who takes possession of any land or building of the board without any right or written permission of the board and or continues with such possession shall be liable to pay damages at the rate of ₹20 per day for each 100 square meter of the land area. Okay, this is in respect of where the house is allotted. Area of the land will be taken into consideration. Here it is a case of flat. हाँ ठीक है हो गया. It is a case of flat.
Yes.
Let's kindly have a perusal of that section 3 itself, my lord, once again. Any person who takes possession of any land or building of the board without any right or written permission of the board and or continue with possession shall be liable to pay damages at the rate of ₹20 per day for each 100 square meter of land area in case of land and at the rate of ₹50 per day each 100 square meter of built up area of each floor of the building.
Are you covered by subsection 1 or not?
No, I am covered by subsection 3.
1
Even-
does not apply. 1 does apply or it does not apply.
I am covered under subsection 3, my
I
lords,
want
for
to
the
know
reason.
that what is the reason you say that 1 does not apply?
And it's one. I am saying that if you lordship peruse subsection 3, my lords, it gives any person.
I just want to know from you.
I am saying.
I want you to respond
Yes,
as to
madam.
why
I am
1 will
saying
not apply
My case will cover under subsection 3, my lords.
and why not under 1?
यहाँ केवल 1 में किया गया है.
Is there anything which shows that 1 does not cover your case in subsection 1?
My lords, what my humble submission is, if the employee who has retired from the board itself, my lords, who should be given the benefits, my lord, which is beneficial to him, my lords, as a beneficial. The reason
Overstay in a allotted quarter in a government.
this provision is for anybody. I am the employee. Anybody who will come, who is not even an employee, who will hold that land or the building for period, my lord, they have themselves said anybody or in continuation of. this is the case, my lord, wherein anybody as well as the persons who is residing as an employee who is continuing. It is not the case that only who is not continuing or who is continuing. It is the case, my lord, that anybody plus the employee who himself is residing and continued after the legal position. That charges will be like this.
You read subsection 3 once again.
Yes, ma'am. Any person who takes a possession of any land or building of the board without any right or written permission.
Just a minute. Were you allotted the quarter without any right or written permission?
That will ceases once I got retired. That will ceases once I got retired, my lords.
No, you have not taken possession without any right. You have continued in possession.
Oh,
you entered into the premises with all rights, but you continued in possession beyond your period of retirement.
Like my lords.
So therefore,
Therefore, my lords, further its rights, my lords, and or continue with such position.
Such possession means what? Illegal possession.
Illegal position.
Continues with such possession means that the entry itself is illegal and you continue with that illegal possession. Your entry is not illegal. Your entry is legal and you illegally continue.
The moment I got retired and thereafter I am possessing it, it is illegal possession.
We'll decide it on that.
Yes, my lords. So my case is covered under this section 3, my lords. And as per this, my lords, I have calculated on each days how much.
You are not covered by, I am not convinced by your argument. So your calculation is immaterial. If this is the bone of contention, then we have to interpret this rule as simple as that. We will not enter into calculation. The point is whether you will be covered under 1 or you will be covered under 3.
Kindly have a perusal of once again, my lord, 1. Any person who without any right or written permission of the board continue in possession means those persons who enter into without having any written permission or any right. In that situation, that will apply, my lords.
उसको आधा पढ़े और पूरा ना
Yes, पढ़ देते हैं. Any person who without any right or written permission of the board in possession of a building belonging to the board after termination of his tenancy in respect to
Therefore, initial entry is pursuant to some tenancy. Initial entry is permissible, legal and valid. And he continues after termination of tenancy. Right? You were giving rent to the board. You were a tenant under the board, even if you are an employee, right? So you are covered by 1, not by 3.
And we are charged only penal rent, not damages.
छोड़िए जो चार्ज कर लिया वही बहुत है. हो गया?
My lords, even then, my lords, if that calculation is taken as my lords, then will that be totaling to amount like 3 and 5 lakh?
If there is any calculation error, you can point out to them. But in principle, you are being governed by 1, not by 3.
Meaning thereby that if I am employee continuing, I am on the disadvantaged position than a person who has entered illegally.
We do not know. That is the law. You get the law amended. We'll go by the spirit of the law. We are not concerned. We are concerned with the law. Housing board has framed these rules for its employees.
Yes.
As a deterrent, that they should immediately evict.
But
So-
anybody who is illegally
It applies even for those who have framed this law.
My lords, even then, my lords, this calculation.
No, we will not enter into the calculation. If you have any calculation error, that you have to point out to the managing director. We will not
That
enter.
liberty should be given.
That liberty is always there. Any calculation error can always be corrected. That's it. Okay. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner had moved earlier before this court in writ petition being WPS number 2486 of 2010, and this court was of the definite view that the claim of penal rent was fully justified by the respondent authorities on the ground of retention of quarter by the petitioner. And on the other hand, the petitioner was also entitled for interest on rupees 96,875, which was arrear of salary during the period from 1/1/2006 to 31/1/2008. And the matter was remitted back to the respondent number 2, the Managing Director, Housing Board, to pass fresh order after verifying the records. The learned counsel submits that the respondents has calculated the penal rent, but they have applied wrong provision of law. He submits that the respondents ought to have applied section 83 capital A within bracket Roman 3 and not section 83 capital A Roman 1. He submits that there would be vast difference in the calculation under the two provisions. The learned counsel further submits that otherwise also there are certain calculation error if the calculation is taken in terms of section 83 capital A within bracket 1. The learned counsel has submitted that the petitioner was an employee of the respondent housing board and was allocated a quarter. He attained the age of superannuation on 1/2/2008 and vacated the quarter on 30/6/2022. And the rent which was being paid by the petitioner on the date of retirement was rupees 1026 per month. He submits that as per section 83 capital A, the petitioner having continued in possession, therefore he is entitled to pay damages at the rate of rupees 20 per day for each 100 square meter of land area in case of land, and at the rate of rupees 50 per day for each 100 square meter of built up area of each floor of the building. He submits that the petitioner was in occupation of a flat of 26.91 square meter. And in terms of then the petitioner would be entitled, and the respondents would be entitled to realize the amount in terms of Rule in terms of 83 capital A within bracket 3. The learned counsel appearing on behalf of the respondents while opposing the prayer has submitted that the case of the petitioner is squarely covered by section 83 capital A1 in view of the fact that the tenancy of the petitioner terminated upon his superannuation and he continued to remain in possession. He submits that the entry in the premises by the petitioner was valid and legal, but his continuation was illegal, and therefore the compensation or penal rent is to be paid in terms of 83 capital A within bracket 1 and not in terms of 83 capital A within bracket 3. He further submits that if there is any calculation error, the petitioner can certainly bring it to the notice of the managing director, who can get the calculation verified through his office, and a fresh calculation can be given.
My lords, one humble prayer. I'm sorry, my lords, I'm interrupting. I'm just showing, my lords, what my senior friend has argued is contrary to the document itself, my lord, which they have themselves at the next, my lords. Kindly have a perusal of Annexure 5, my lords,
They
supplementary.
have calculated, and under which terms?
They have calculated under T3A3 itself, my lords, and given me notice, my lords. Kindly have a perusal
तो
of.
वहीं चले जाइए, फिर क्यों विड्रॉ करके चले जाइए उनके पास, फायदा हो जाएगा आपको. हम तो नहीं पास करेंगे ऑर्डर.
At least this should be mentioned in my
notice जो हम लोगों
का है Annexure A to my counter affidavit.
When it comes to interpretation of sections, we will interpret the section as it is.
Definitely, my lords, but I should be, my submission should be reflected only this much, my lords.
तब फिर आप क्यों आए हैं यहाँ पर? आपका तो कैलकुलेशन ही 83 A3 के अनुसार किया.
Earlier they have calculated this much, and only notice has been given. This time they have not given that how much it should be calculated. Only submission to this, my lords.
नोटिस जो हमने दिया है एक उसको देख लिया जाए Annexure A to my counter affidavit clearly उसमें mentioned है page number 11.
Yes.
Clause 1 आपने सेवा निवृत्ति की अवधि के समाप्ति के बाद भी मकान संख्या 1600 आवासीय पर कब्जा जारी रखा है. अतः बोर्ड मकान के निर्धारित 1026 प्रति माह का 3 गुना प्रति माह के दर से नुकसान के रूप में भुगतान पाने का अधिकार है. 3 गुना जो है दैट इज
In terms of
83A1.
That's right.
तो उसके नीचे क्लॉज 3 लिखा गया है. अतः भूमि के लिए प्रतिदिन 20 रुपये प्रति 100 वर्ग मीटर क्षेत्रफल की दर से तथा भवन मकान के हर तल्ले के लिए 50 रुपये मकान के हर तल्ले के लिए 100 वर्ग मीटर क्षेत्र की दर से नुकसान के रूप में चुकाने के भागी है.
Damages.
दैट इज डैमेजेस.
तो इसी पे कैलकुलेशन हम किए हैं.
Here we have charged penal rent in terms of 83A1.
Okay, and you have not charged damages.
No, not damages.
You don't intend to.
अब तो जो कर दिए हैं हम तो हमारा तो
हाँ बताइए कौन सा?
Supplementary of
चाहते हैं तो फ्रेश कर
Annexure
देंगे.
5. Annexure 5, my lord, supplementary affidavit that I have. Earlier, eviction notice was issued, my lords, in 2015. They have calculated it, my lord, for nearly 8 years to be 31,185, my lords.
The learned counsel for the respondents has referred to the notice dated 27/9/2016 filed along with the counter affidavit, which was issued after the order and has submitted that as per the notice the petitioner was supposed to pay not only the penal rent but also damages. Penal rent was to be assessed in terms of 83A within bracket 1 and damages was to be assessed in terms of 83A within bracket 3. However, ultimately only the penal rent has been calculated in terms of 83A capital 1 and read with the judgment passed by this court in WPS number 2486 of 2010 decided on 13/12/2020. In response, the counsel for the petitioner has referred to supplementary affidavit dated 28/11/2023 wherein he has annexed a copy of the calculation made by the respondents, and he submits that they had initially demanded the amount of damages in terms of 83 in terms of section 83A within bracket 3, and therefore the insistence on the by the respondents for calculation of penal rent in terms of 83A within bracket 1 is not sustainable. Yeah.
Yes. Highly right.
After hearing the learned counsel for the parties, the dispute between the parties is in connection with section 83 capital A of the Bihar State Housing Board Act 1982. The foundational facts, which is quoted as under, the foundational facts as narrated by the counsel for the parties is not in dispute. The petitioner admittedly attained the age of superannuation on 1/2/2008 and was occupying a quarter duly allocated to him by the respondent board at a monthly rent of rupees 1026 at the time of his retirement, but continued to remain in possession of the same till 30/6/2022. It further appears that earlier one notice dated 22/7/2015 was issued to the petitioner by referring to certain calculation which according to the petitioner was in terms of rule 83 within that 83 capital A within bracket 3. However, from the records of this case, it appears that the petitioner had moved this court earlier in WPS number 2486 of 2010, and it was clearly held that the petitioner would be liable to pay penal rent. The rule 83A within bracket 1 essentially relates to those persons who have entered into possession of the property on account of tenancy, and after termination of tenancy they continue to remain in possession. Considering the fact that the petitioner was allotted the quarter or flat on monthly rent, therefore it cannot be disputed that the petitioner was a tenant under the respondent board. However, the petitioner continued to remain in possession after his retirement, and his tenancy was coterminous with his services. In such circumstances, the case of the petitioner would be covered under section 83 capital A within bracket 1 of the aforesaid act. The said provision relates to payment of penal rent inasmuch as 3 times the last paid rent is to be realized, and this court has categorically held in the writ petition being WPS number 2486 of 2010 that the petitioner would be liable to pay penal rent. In such circumstances, there was no question of further applicability of section 83A within bracket 3 inasmuch as the said subsection deals with such person who take possession of land or building of the board without any right or written permission and continues with such illegal possession. In the present case, the petitioner has entered into possession as a tenant and continued to remain in possession after termination of tenancy, and therefore the case of the petitioner is covered by section 83 capital A within bracket 1 and not by section 83 capital A within bracket 3. In such circumstances, the issuance of notice dated 25/7/2015, which was issued prior to disposal of the writ petition, is of no consequence, and therefore it is held that the case of the petitioner would be governed by section 83 capital A within bracket 1 and not by section 83 capital A within bracket 3. Accordingly, the argument of the petitioner that the wrong provision of law has been applied in calculation of penal rent is devoid of any merit and hence so far as any error in calculation is concerned, the same can still be brought to the notice of the respondent number 3 by filing a representation and accompanied with the own calculation of the petitioner duly certified by a chartered accountant. Okay? If such a representation is filed by the petitioner before respondent number 3, the respondent number 3 shall look into the grievance of the petitioner regarding calculation, get it verified by his office, and pass a reasoned order in connection with such calculation. If the petition within a period of 15 days from the date of such representation to be filed within a period of 15 days from today and 1 month from the date of representation. The reasoned order be communicated to the petitioner through mail, through speed post at the address to be provided by the petitioner in his representation itself.
15 days पहले 1 month पहले चार्टेड कंसल्टेंट
1 महीना। और आपको कोई रिबेट चाहिए, कोई इंस्टॉलमेंट चाहिए?
नहीं, they have already recovered.
They have recovered.
Yes,
हाँ, तो adjust करने का director.
Adjust करने का director. They have not adjusted as per even the order of the honorable court. Any minutes? One thing was there.
Adjustment reducing balance पे होता है।
इसमें था कि ये जो हमको areas
आपका चार्टर्ड अकाउंटेंट आपको ठीक से कैलकुलेशन कर
Diminishing balance method है accounting का, अगर वो लगा देगा तो इनको और कम मिल जाएगा।
उसमें एक और था कि मेरा 12% CPF amount था,
वही
वो हमको मिल जाता है।
The learned counsel has also submitted that the calculation was required to be made in terms of the orders passed by this court. है ना?
At least वो CPF के लिए मिल जाएगा तो मिल जाएगा और मिलेगा।
If the petitioner is found entitled for any refund, the as per the recent order, the same be remitted to the petitioner within a period of 15 days from the date of the receipt.
Passover case item 19, WPS 1381 of 2023.
Where is the petitioner?
15 years.
आपको बताए थे ना मिस्टर अतनु बैनर्जी बहुत बिजी रहते हैं.
मैं थे अभी था तो
WPS number. I know he's a busy counsel. Are it's a pleasure to say you should take it in a very positive way. I know that he has very contested cases, so I know that.
a contesting lawyer also, my lord.
He's a very good counsel.
Yes.
WPS number 1381 of 2023, counsel for the petitioner seeks adjournment. बताइए कब रख दें? कौन सा शुभ मुहूर्त आप निकालेंगे?
आज ही 2:15 में
नहीं 2:15 में नहीं हो सकता. बताइए कब करें?
किसी भी डेट
29 जुलाई.
Passover case item 22, WPS 1756 of 2023.
Where is the petitioner? First half में कोई आए थे ना?
हाँ टाइम भी है 1 बजे के लिए हुआ.
Nobody appears on in the first round. The matter was passed over at the request of the learned counsel for the petitioner. When the case is called out again, nobody appears on behalf of the petitioner. Post this case on 29 July. 29 July.
Item 24.
Respondent का presence record.
Item 24, WPS 1983 of 2023.
WPS number 1983 of 2023. Counsel for the parties are present. Counsel for the petitioner seeks adjournment to file a rejoinder to the counter affidavit. How much time do you need? Post this case on next Tuesday in the supplementary cause list. Let the rejoinder be filed by next Monday. Failing which no further adjournment will be granted.
Item 25, WPS 2064 of 2023.
2 week time may be granted for filing rejoinder in this case.
WPS 2064 of 23. Counsel for the parties are present. Counsel for the petitioner prays for time to file rejoinder. Let the rejoinder be filed by 23rd July 24. Post this case on 30th July.
Item 26, WPS 2083 of 2023.
Who is for the petitioner?
Apologies, Your Lordship.
Your Lordship, the matter relates to regularization. I have been working continuously since 2008, Your Lordship. And in their counter also, they have nowhere stated that my appointment was illegal or that I was not appointed by the competent authority. If I may draw
Were you working against a sanctioned vacant post?
Yes, Your Lordship, I have made that statement in para.
Was your employment on contractual basis?
Yes, it was. Initially, I was appointed by the Deputy Commissioner as a computer operator in the year 2008. It is at Annexure 1, Your Lordship. Purview of this order is what I was appointed.
This is the advertisement?
Not the advertisement. They needed a person, so for 2 months initially they had appointed me, Your Lordship. And thereafter they have been continuously renewing my appointment up till 2023 as 2024 as well, Your Lordship. Till date I have been continuously working with the department.
You are still working?
Yes, Your Lordship, I am still working.
Was this appointment by virtue of advertisement?
No, Your Lordship, not advertisement, but I was appointed by the competent authority, which is the Deputy Commissioner. And initially, though my pay was on a daily basis of 183 rupees, later on, by the virtue of Annexure 4, it was converted to a salary of 16,480 rupees, Your Lordship. And in between also, Your Lordship, when there was an advertisement published for appointment of clerks in the departments, I had duly applied in that exam and I had qualified and my name was posted at serial number 48 also, Your Lordship. That is Annexure 2. So I am duly competent and I have been carrying out this work for a really long time. And by virtue of Annexure 11, they have been making the posts and if I may draw Your Lordship's attention to
Have your case been declined?
No, Your Lordship, but a recommendation had been given.
Where is that?
For
regularization?
Yes, Your Lordship.
Where is that?
The regularization is at page 36, Annexure 6, Your Lordship. The Deputy Commissioner himself made the...
No. Regularization is always considered by a committee constituted for the purpose. He has got no business to write a letter for regularization.
Very well, Your Lordship.
Has your matter been placed before any committee for that purpose? What is the last document you have annexed? What is it?
The Annexure 11, Your Lordship, it is by virtue of this that a lot of computer operators were promoted to the post of LIPIC, that is clerks. If I may draw Your Lordship's attention to page 61.
Clerk is a promotional post?
Not promoted, regularized as... Absorbed to the post of accountant clerks, Your Lordship. Page 61 is very important.
So why your case has not been considered?
Your Lordship, in their counter affidavit, only one paragraph they have written to this effect. That is para number 15, Your Lordship, wherein they have just said that it is humbly stated and submitted that the petitioner was kept on daily wage basis for 3 months from 1/1/2008 to 31/3/2008 for data entry. There is no letter or guideline of government regarding the regularization of said daily wages computer operator. The petitioner is not entitled to get observed on sanctioned post of accounts clerk as alleged. Accounts clerk are selected on basis of merit through examination conducted.
Is there any computer data entry operator who has been absorbed as a...
Yes, Your Lordship.
Who is that person?
Page 61, Your Lordship. And they have given an explanation in this particular thing only that उक्त सभी कर्मियों की नियुक्ति के समय निदेशालय में कंप्यूटर ऑपरेटर, डाटा एंट्री ऑपरेटर, लास्ट पैराग्राफ का कोई पद स्वीकृत नहीं था, सिर्फ लिपिक का पद स्वीकृत था। भविष्य निधि निदेशालय तथा जिला भविष्य निधि कार्यालयों में लिपिकों की कमी के कारण भविष्य निधि निदेशालय द्वारा समय समय पर निर्गत आदेशों के आलोक में इन कर्मियों से नियुक्ति से लेकर अब तक कार्यालय में कंप्यूटर संबंधी कार्य के अतिरिक्त लिपिकीय कार्य भी करते जा रहे हैं। इस प्रकार किए जाने वाले कार्यों के आधार पर वस्तुतः है ये लिपिक के पद से के विरुद्ध ही नियुक्त एवं कार्यरत हैं। भविष्य निधि निदेशालय अंतर्गत इन कर्मियों की नियुक्ति के समय लिपिक का पद स्वीकृत है। वर्तमान में भविष्य निधि निदेशालय एवं क्षेत्रीय कार्यालयों में लिपिक के स्वीकृत 147 पदों के विरुद्ध 134 पद रिक्त हैं। इन पदों में आरक्षण रोस्टर से के
So you were also working as a clerk?
I was working as a data operator, but I was doing all the works of a clerk, Your Lordship. And
You were in
this,
the same office?
Not in. They have been multiple offices, Your Lordship, that has been regularized under this. One of them has been also the department where I was working.
Which department were you working?
I was working in the Jila Najara Samajik Suraksha Koshank, Social Security.
Social Security?
Self-guided.
Cell. Which is a document which says that you were also working as clerk and there is a vacant sanction post with regard to that clerk.
Your Lordship, in my rejoinder,
you can't make out a new case in rejoinder.
In rejoinder, I've annexed the documents which shows that I have.
This is something new. Then they'll have to file a supplementary counter affidavit. You come out of it. This is the habit in Jharkhand High Court. The entire case is based on rejoinder. When you annex this document, was it not your duty to bring on record the documents regarding parity? If you claim parity, you have to show that you stand on the same footing. Then? What is it that you have brought on record through rejoinder? Show me that you were working as a clerk and discharging the duties of a clerk. And there was a vacant sanction post in the office with regard to that clerk.
Your Lordship, if I may draw your attention to para 9 of the rejoinder that I have filed.
Your statement will not do, madam.
I have annexed a letter also.
You show me that letter status. That since 2008 you have been working as a clerk. Show us.
Granted one case passover, I'll answer both the queries by this court with the specific paragraphs and pages, Your Lordship.
Now, what is the name of the petitioner?
Rajesh.
WPS number 2083 of 23. Counsel for the parties are present. Counsel for the petitioner submits that the petitioner has been working on as clerk as well as computer operator right from initial date. What is your initial date?
1/1/2008.
1/1/2008, and there was vacant sanction post available for clerk, and therefore the petitioner is entitled for being absorbed as clerk, as has been done in the case of such similarly situated persons. She submits that the post of clerk is still vacant, where the petitioner can be absorbed / regularized. The counsel for the petitioner seeks adjournment for further arguments post tomorrow. कल आएंगे अच्छे से लेकर आइए, ऐसे हम डिस्पोजल ऑफ रिप्रेजेंटेशन का ऑर्डर नहीं करेंगे.
Item 27, WPS 2084 of 2023.
Madam, now serial number 22.
This is 22.
27.
I was in some other court.
No, we have already passed on.
My
All
parents.
correct. You cannot record your appearance. Yes. This serial number, this is 2084.
This is compensation appointment method validation. Petitioner father died on 25th February 2010. Soon after that, it is on
25 to 2000?
25 February 2010.
Okay.
Soon after that, on April 26, 2010, I have given my first representation.
Okay.
But due to ongoing criminal cases against me, my application was on hold for some time. Again, it resumed in the year 2013, where I submitted my application along with the judgment of the acquittal.
Where is
16
what is the
4
date of acquittal?
A date exactly is not known to me.
Where
On
is the order of
16
acquittal?
I have submitted it on 16/4/2013 to the.
In which section were you accused?
It was under I think 302. My lord.
Please. Your date of acquittal is?
I have submitted my acquittal report on to 16/4/2013.
You have to, where is your date of acquittal?
No, I have not written it yet. Exactly on what date I got acquitted is not known to me. That is not under dispute, my lord.
We do not know. Maybe that you were acquitted prior to that.
On 16/4/2013.
Then what happened?
From since then, various interdepartmental communication is going on, but my application is still pending.
Why have you come in 2023 after expiry of 10 years?
No, I have given 4 more representation after that.
How does that make a difference? Giving representation will extend your time.
Actually, they were proceeding with they have communicated in between. Till 2018, they have communicated. After that,
Then what made you come over here? You are seeking a mandamus.
yes,
You have filed a counter.
Yes, Your Lordship.
What have you stated in the counter?
The paragraph, Your Lordship, the important, Your Lordship, may I read?
Yes.
May I read, Your Lordship? That before the giving the para, I replied to the governments made in the read applications that answering respondents gives leaves to honorable court to state certain facts related to the merits of this case. It is stated and submitted that the father of the read petitioner was working as 4th grade employee in Krishi Utpadan Bazaar Samiti in Godda, and he died on 25/2010 while he was in active service. It is admitted fact that the petitioners, that the father of the petitioners left behind 2 sons and 2 married daughters. According to the family certificates granted by the circle officer, Kasik districts Nawada, Bihar, the petitioners and his elder brothers were aged about 35 and 47 years old, respectively, on the date of issuing the family certificates number 1 dated 7/1/2011 were administered to of the petitioner. It is also submitted that the mother of the petitioners has already been died prior to the father on 12/3/2006. After the death of his para 9, Your Lordship, after the death of page number 9, after the death of his father, the petitioners has submitted an applications on 26/4/2010 along with all the requisites documents for his appointment on compensation ground, address to the Secretary Krishi
Utpadan Bazar Samiti Kutta. In this regard, the Managing Director of the Jharkhand State Agriculture Marketing Board also requested to the answering respondent to consider his case white letter number 873 dated.
This respondent board is a self-financing
Yes,
institution.
Thereafter,
There is no scheme for compassionate appointment.
No, they have given compassionate appointment to so many people.
You are giving compassionate appointment to many people.
I am giving my lord, but petitioner.
They have annexed.
File counter affidavit.
You have also filed your counter.
Page number 22.
22.
Respondent 283.
Yes.
पेज नंबर 22 कंसर्न उल्लेखनीय है कि मिल सरकारी सेवक स्वर्गीय सुधार ये गुड्डा डीसी लिखे हैं प्रधान सचिव पर्सनल डिपार्टमेंट को और डायरेक्शन के लिए उल्लेखनीय है कि मिल सरकारी सेवक स्वर्गीय सुभाष प्रसाद सिंह की मृत्यु दिनांक 25/2010 को हुई थी। आवेदक श्री तरुण कुमार लुकम्पा नियुक्ति आवेदन पत्र 15/6/2013 को सचिव कृषि उत्पादन बाजार समिति गोड्डा को समर्पित किया गया। आवेदक की जन्म तिथि 9/11/1975 है। आवेदक की उम्र नियुक्ति हेतु निर्धारित उम्र सीमा से अधिक है। इसमें डायरेक्शन मांगे हैं पर्सनल डिपार्टमेंट से और फर्दर।
बट ही इज ओवर एज।
ओवर एज मांगे दिया हुआ ओवर एज है और ये डायरेक्शन सीख के पर्सनल डिपार्टमेंट से इसमें क्या मार्गदर्शन दिया है, क्या एज होना चाहिए।
What do you have to respond to that?
Yes.
You were over age.
Yes.
And now more than 12-13 years have passed.
No, it is due to their problems. They
So
have
we can't-
they have
see, you
delayed
have
the-
not approached the court at the right time.
I have
So
approached
you have
the-
survived for 12 years.
I have approached the authority time and again. I have given 5 representations so far.
Keep on giving representation.
They have appointed, see, annexer B of their respondents.
You were over age.
No merits. On that date, I have annexed, I think, my.
On the day you filed your application in 2010, right?
Yes.
You could not have been appointed because you were facing criminal charges.
Yes.
And in the meantime, you became over age. The matter ends. So ultimately, your application of 2010 is of no use. Because you could not have been नहीं पहला शायद 2010 में किया।
Date should be calculated on the date of my first representation when it is according to.
But you could not have been appointed according to you only. You could not have been appointed
But
because
I
you
have
were
given
facing a
representation.
criminal.
That
It
is
does not
their
make any
duty.
difference. On the day you filed your first application, according to you only, you could not have been appointed.
They kept my application on hold. They haven't rejected my application till 2018. Means this respondent number 4 has responded, and they sought direction from this karmic department.
I've heard you. Your representations were pending, right?
Yes.
This is what you want to say.
They sought direction from karmic department, which is still not given, and collector is still waiting for that direction.
If you want to pursue, you pursue. Otherwise, I will not grant you relief. I'm making it very clear.
It is
If you want to pursue your remedy with them, you pursue. We don't want to say anything. After 12 years of death, we are not going to grant you any relief.
Your Lordship, the
A person-
representation is pending, Your Lordship. Let it be disposed of the respondent authority, Your Lordship.
Delay from the side of authority, my lordship.
Then you withdraw. You see, they are ready to give you. You are ready to take. You withdraw. आपका काउंटर क्या इन्होंने बनाया है? फिर आपका यही सबमिशन लिखा देंगे, समझ गए ना? मॉडिफाई भी नहीं करेंगे. You have to give the appointment. Then agriculture produce marketing board says that they have no finance. पेमेंट कहाँ से करेंगे? They are self financing body. इनको एड देने वाले हैं आप. सैलरी डिसबर्स करेंगे इनका? Yes. State will disburse the salary for the petitioner.
No.
Then, what representation are you talking about? और आपके पास इनका क्वेरी आता है, चुप लगा के बैठ जाते हैं। क्यों नहीं करते हैं क्वेरी का जवाब कि पैसा नहीं देंगे, यू नो योर ओन अफेयर्स, वी आर नॉट कंसर्न। यस, चिट्ठी लेके बैठ जाते हैं, रिट पिटिशन फाइल होता है, that they are pursuing their representation, and in the court you submit that let the representation be disposed of for compassionate appointment after 12 years. सेकेंड हाफ में ऑर्डर करेंगे हम। सुन
सीरियल 18 में मैडम मेरा कल के लिए रखा गया है, उसको रिजॉइंडर फाइल करना है।
कुछ नहीं, अब कल आप बहस करिए।
कल रिजॉइंडर टाइम
नहीं, आपका अपीयरेंस कैसे रिकॉर्ड करेंगे बताइए। इससे क्या होगा, आपका अपीयरेंस रिकॉर्ड करके क्या होगा बताइए।
हमसे नॉन अपीयर तो नहीं आएगा, पार्टी को तो पता है कि हम आए थे।
आपको पता है आपको कितना कितना आपके क्लाइंट को नुकसान हो जाएगा।
आई नो मैम,
तो
आई एम रेडी टू आर्ग्यू।
अपॉइंटमेंट प्रोसेस में एडजर्नमेंट का क्या रेलेवेंस है और कितना इम्पैक्ट है, समझ में आता है। उनको बुला के लाइए मिस्टर पिपरवाल को, ठीक है। ठीक है, ऐसे नहीं नुकसान करिए अपने क्लाइंट। प्रोग्रेस भी चला गया, इसका प्रोग्रेस भी चला गया, अब हम चेंज नहीं कर सकते। ठीक है, इनका अपीयरेंस रिकॉर्ड कर दीजिए, मेमो ऑफ अपीयरेंस फाइल करिए, क्योंकि ये सब रिकॉर्डेड प्रोसीडिंग है ना। कल को बोलिएगा हम तो अपीयर नहीं हुए थे, वीडियो देख लीजिए। हाँ, मेमो ऑफ अपीयरेंस साइन करके प्रॉपरली फाइल करिए, तभी आपका अपीयरेंस रिकॉर्ड होगा, नहीं तो हम नहीं करेंगे। और सिर्फ अपना नाम दीजिएगा, किसी और का नहीं। सीनियर वीनियर का नाम मत दीजिएगा, यहाँ कभी मत करिए ऐसा। आई एम टेलिंग ईच वन ऑफ यू, क्योंकि जब आप मेमो ऑफ अपीयरेंस यहाँ फाइल करते हैं और 4 आदमी का फाइल करते हैं एंड दे आर नॉट अपीयरिंग, दीज आर ऑल रिकॉर्डेड प्रोसीडिंग्स। आई विल इनिशिएट कंटेम्प्ट प्रोसीडिंग्स अगेंस्ट यू। आई एम फाइंडिंग इट। सीनियर अपीयर नहीं होते, उनका अपीयरेंस मेमो रहता है, हम वीडियो रिकॉर्डिंग पर ही हम कंटेम्प्ट प्रोसीडिंग इनिशिएट कर देंगे। यू कांट डू दिस। अपना अपीयरेंस दीजिए, हम बता रहे हैं यार, दिस इज समथिंग वेरी सीरियस। हम देख रहे हैं यहाँ पे एक से एक दिग्गज लोगों का नाम अपीयर हो जाता है, उनको हम तो कितना साल से कोर्टे में नहीं देखे। एक आध ऐसा सिचुएशन हम देखे हैं, करेक्शन करते समय हम नाम काट दिए थे because he never appeared in the court. This is not proper. Those people who are not appearing in the court, please don't file their appearance memo. I will not accept it. ठीक है, it is your responsibility. जो साइन करके देगा उसी को हम पूछेंगे, और ऐसा घिसा पिटा साइन मत किया करिए, बाकायदा एनरोलमेंट नंबर के साथ अपना अपीयरेंस मेमो दिया करिए। जी कोई बात नहीं, 29 जुलाई को, ठीक है।